Bună dimineața!
Good morning. I think we could start. Dear participants, welcome to the second day of the annual forum on justice reform and fighting corruption. The second day is as interesting as the first one. We will talk about the vetting process, what happens afterwards. Afterwards, we will discuss the achievements of fighting corruption, and last but not least, we will discuss the seizure of criminal assets. And now I want briefly to introduce the panelists of the first panel of discussion. We will discuss with the representatives of the Superior Council of Magistrates and Prosecutors, representatives of Pre-Vetting and Vetting Commission. Last but not least, we have a special guest, again, from Albania, and he will discuss the vetting process in Albania. We will start the session with a Vox Populi and a presentation developed by LRC colleagues. I will present a couple of figures to have a general understanding of the subject. Dear colleagues, please showcase the presentation. So the results of the vetting procedure are presented here by the Ministry of Justice. These are the figures dating November 2025. So around 287 subjects, judges and prosecutors were part of this vetting process. The promotion rate is 36%, also 32% of them resigned, and 32% of these subjects did not pass the vetting process. Now, the support provided for the adoption of vetting laws. So, Magenta Consulting Company conducted, together with LRC, a survey in 2025 to understand the perception. And you can see here that 21% of prosecutors, 57% of lawyers, and 34% of judges consider that the vetting laws are good. When it comes to their availability to participate in vetting process, 70% of prosecutors and 81% of judges stated that once they become the subject of this vetting process, they are available to take part in. So you can see that there is big difference between the approval of vetting laws and their availability to participate in this process. We also discussed the challenges of the vetting procedure in 2024, and we have highlighted a couple of reasons stated by the subjects. We've wanted to present this slide to understand what happens in a year, what kind of challenges have been solved, what of them are still available, and in this panel of discussion, we will see how we can tackle them. And here there are a couple of the reasons. The lack of qualified staff and insufficient human resources led to this long vetting procedure. The lack of cooperation between institutions, candidates that did not cooperate, and many others. Also, we collected the recommendations from the last year and to compare them with the recommendations this year. Last year we received the following recommendations: to strengthen the vetting, pre-vetting and vetting procedures, to improve the institutional cooperation, to provide better transparency, better communication, to maintain human resources in the system, and also to provide an exit strategy. How exactly to transfer this know-how, how to strengthen Superior Council of Magistrates and prosecutors after the end of the Commission's activities. This is all from my side, and now I want to give the floor to Liliana Barbaroșie, who will manage this panel of discussion. My name is Liliana Barbaroșie. It's a pleasure to moderate this panel of discussion. It's the second day of the forum, and today we can freely discuss about the vetting that is finalizing, but still there are certain gaps, controversies, some pressures on the system. And the key question for this panel of discussion is what happens afterwards, who takes this expertise. We want to know whether the Superior Council of Magistrates and Prosecutors can overtake these responsibilities, whether they have the mandate and the resources, or whether there is a need to build up a separate mechanism. So this session is about post-vetting procedure. We are not going to discuss whether it's good or not to have a vetting procedure, but what happens afterwards. Therefore, I kindly ask the panelists to be brief and concise. But first of all, let's discuss the reality of the system, the way it is perceived by citizens. We do have a Vox Populi video. Let's watch it, and afterwards we will start the discussions.
pedepsiți sau infractori sau vinovați de anumite fără de lege să fie mai publicați.
Eu personal am o încredere destul de înaltă în sistemul judecătoresc. Cred că măsurile de verificare sunt destule.
La o anumită perioadă de ani ar trebui din nou să treacă prin filtre de astea, poate nu atât de serioasă, dar ceva la nivel de bază.
Eu cred că da, doar că, nu știu, oricum o să persiste corupția pentru că are rădăcini prea adânci.
Să sperăm, dar nu știu, adică deja sunt tot speranțe, vreo 30 de ani de când tot lumea speră ca să fie schimbări, dar nu пrea să văd.
У меня, как у гражданина Молдовы, не появится больше доверия к судьям после того, как они пройдут тест. Потому что у меня нет доверия к самому тесту, к этому ветингу.
Eu sper. Avem cum o guvernare și ar trebui să mergem să punem la capăt justiția asta ca să putem să ne integrăm și noi în lumea asta care trăiește mai bine.
Minunat material, e una.
So that's very interesting material. I'm always surprised to find out how well people understand the processes. Yes, it's clear that people have high expectations, and these perceptions will serve as an important milestone for our discussions. So it is my pleasure to invite the participants for this first session. Sergiu Karaman, chairperson of the Superior Council of Magistracy, Dumitru Oba, the president of the Superior Council of Prosecutors, Nadezhda Hryptievsky, member of Pre-Vetting Commission, Andrei Bivol, president of the Vetting Commission, Virginia Moraru, deputy president of the Vetting Commission for Prosecutors, and Edmund Ahmeti, director, program division for programming, standardization and harmonization of the regulation framework of the Ministry of Finance, Albania. So let's start the series of presentations. So please be brief and to the point. Mr. Karaman, you have the floor, 5-7 minutes. Good morning, esteemed moderator, dear colleagues, esteemed development partners, ladies and gentlemen. The topic of this discussion panel, if there is any life after vetting, well, it should not be a rhetorical question. This is a question related to institutional maturity, political honesty, if you want, and responsibility towards the future of the justice sector of this country. From the very beginning, I would like to say that yes, there is life after vetting, and not just any life. There is a type of life that we are building soundly, consciously, a life that we're building in a coherent manner with institutional engagement, considering the lessons of this unprecedented exercise, which is called vetting. The external assessment of judges and prosecutors was an exceptional response to an exceptional crisis of image and crisis of trust. This is not an this is not a purpose, a final purpose. The Vetting Commission does not replace the judiciary's self-managed authorities, and it is not a permanent mechanism, that's for sure. Vetting is a tool that we use to reset the whole system. It's an integrity filter, is a clear signal to the society as well as to the external partners that justice in the Republic of Moldova is ready and open to pay costs, the needed costs, in order to regain people's trust. But any exceptional mechanism like vetting, like this one, if it is artificially extended, then it loses both its legitimacy and its efficiency. So, the correct question is not whether vetting was needed at all, but what should we do next when this temporary extraordinary measure ends? Vetting offered to us some tough but very valuable lessons. The first one is that integrity cannot be assessed only retrospectively. A healthy system should prevent deviations, not only punish them. The second, lack of regulatory and procedural predictability affects trust. 3, judiciary self-management institutions cannot operate efficiently unless perceived as administrative units rather than centers that have a real accountability. And maybe the most important lesson that we've learned from this exercise is that integrity cannot be imported, cannot be outsourced, and cannot be maintained through permanent exceptions. It is built day by day through strong institutions, through rules and competent people. For the Superior Council of Magistracy, the post-vetting period will be the real test. A mature CSM should fulfill 3 important roles. Number 1, it should guarantee continuous independence and integrity. It should design the judiciary career policies, and it should defend independence and should also bring the systems to account when needed. So to have that, the integrity principle should be well anchored in the legal framework. We need to have clear, transparent and predictable assessment criteria, firm and equitable disciplinary procedures, and real decisional transparency. So we have to gradually move from this vetting process, which is an external assessment, to an internal mechanism. A major risk that might occur in the post-vetting period is fragmented reforms. The external assessment will not produce a sustainable outcome unless it comes hand in hand with reform of courts, real digitalization of court processes, reform of the National Institute of Justice, and predictable salary and HR policies. And judge with high integrity, but who is overworked, underpaid, and deprived of administrative support is not a sustainable solution in the long run. That is why the Superior Council of Magistracy supports an integrated approach, meaning integrity plus competencies plus appropriate working conditions for judges. I have a very pragmatic question. What will happen with the competencies and infrastructure created during the vetting process? My answer is clear. They should not be lost. The state invested significant resources. It used international expertise and confidence capital. So this experience needs to be factored in the national integrity verification mechanisms. It should be used by the Superior Council of Magistracy, Disciplinary Collegium, Integrity Collegium, National Integrity Authority, So we do not need another vetting, but we need to build an institutional culture of integrity. And a key message for the post-vetting period is the following. Judiciary independence is not incompatible with judiciary accountability. No, they are intercorrelated, and a system that only asks for independence but avoids responsibility undermines its own legitimacy. The Council will keep defending firmly the judges' independence, but at the same time it will insist on clear ethical standards, swift response to any deviations, and honest communication with the society. The implementation of the justice sector reform strategy is coming to an end, and we start a new era that is marked by the EU accession negotiations. And in this context, the Moldovan justice is not assessed only internally, but it is assessed also at the European level on a comparative basis. And to cope with this, we need predictable procedures, stable institutions. So vetting was a kind of bridge. And what we have to do next is to build the road after passing that bridge. And as a conclusion, yes, there is life after vetting, but this life will not be easier. It will be more responsible. It will request fewer exceptions, more coherence, and more institutional commitment. CSM assumes this role, but it is not a defensive role, not a tokenistic role, but a proactive and visionary role. We do understand that a genuine justice sector reform cannot be measured by the number of completed assessment procedures. It is measured by regained trust and trust that maintained. Thank you very much, Mr. Karaman. We took note of your idea and we'll come back to it. So who should take over the assessment after vetting comes to a close? Now let's hear another perspective. Dumitru Obada, President of the Superior Council of Prosecutors. Good morning, ladies and gentlemen, dear colleagues. Now, I would like to continue the idea of Mr. Karaman. I liked it very much, that vetting is only a bridge, and the road after that bridge should be built by us. And there is another statement that the road to hell is made of good intentions. So we have to make sure that our road is built in an appropriate way. So yes, there is life after vetting and after other processes, but of course the quality of life can be different depending on the results of the vetting process. Regarding the vetting per se, vetting is not an end solution for enhancing the situation in the judiciary and gaining people's trust. This is a tool that can be used to achieve this result. We can see it as a sword with two sides. Why two sides? Because on the one hand, yes, we have this filter in order to filter out the judges and prosecutors that do not meet the ethical and financial criteria. On the other hand, we would like for the Commission to be able to perform high-quality assessment, but for that, resources and time is needed. But we do not have this time. All of these processes last, assessing new prosecutors and judges, employing them, appointing them. This is determined by the outcomes of the vetting, which is currently done by Commission number 2 and Commission number 3. That is why the longer it takes, people's trust in the vetting decreases and people's trust in justice sector reform decreases. But again, we cannot prioritize people's expectations over quality, and also we cannot prioritize quantity over quality. That is why, on the one hand, we have the vetting process, on the other hand, we have the time and efforts that have to be invested in this process in order to have the expected outcomes. I want to give you some data. About 25 prosecutors resigned because of the vetting. In the Superior Council of Prosecutors, we have 10 reports positive confirmed, 3 negative, and one is returned for reassessment. A positive one and a negative one was also returned for reassessment. So in the case of our work with Commission number 3, we have a very good cooperation with them, of course, without going into the merits of the case. We are discussing with them, we are talking to them in order to understand the minimum standards during investigations, to make sure that we do not have different approaches between different panels of Commission number 3, and to have the same standards for the evidence, how this evidence should be taken into account in order to have a single and shared understanding by all the panels, and for the reports not to be, of course, copy-paste, but for these reports to be built on common understanding. Because what we do not want to have is a non-uniform practice. We are sure that Commission number 3 works at high speed, considering also the difficulties that we had during 2024 and 2025. Commission number 2, we can see that it's finishing the planned activities. I don't know, maybe it's a crazy idea, but maybe it could take over a part of the tasks assigned to Commission number 3. So it could be moved to Commission number 2. But we will see the reaction of Mr. Bevel to this idea, because they have already the needed expertise developed, because we need to use all of our engines in order to be able to reach the end point. So what we are doing as the Superior Council of Prosecutors, this March we established the disciplinary and ethics collegiums. This process lasted. The biggest barrier was the lack of pre-vetting outcomes, and because of that we did not have the possibility to organize competitions and organize assessments. So first we have to do the assessment, entry into the register, and now only after that we can organize employment competitions and then appoint prosecutors. Now everybody is interim. So our biggest task now is to fill in these positions according to the new judiciary map. And we want to align the map of prosecution offices with the judiciary map. So now we're developing a new regulation. Similar to Commission number 3, we are checking ethical and financial integrity criteria. We have developed a new regulation. We approved it. About 90 prosecutors were notified. 85 of them are being assessed extraordinarily. More than 60 public and private institutions were contacted and to obtain from them evidentiary materials in order to assess those 85 people who have applied for position of chief prosecutor and deputy chief prosecutor. So if we manage to do it in the first half of 2026 to finish the assessment and to organize the competitions and then to appoint those prosecutors, then more than 50 positions will remain vacant. That's why we focus as a matter of priority on the assessment, then we need to conduct that competition. This situation that we currently have, inability to appoint prosecutors, is a dissuasive factor because they would like to have their position confirmed and they want to contribute to making justice. That's why, as I've said, this is a priority for us, for the Superior Council of Prosecutors. So I would like to wish wisdom and patience to all members of the vetting commission, and we can assure you of our support. Thank you very much. Thank you, Mr. Obada, for the updated data. Thank you for the solutions suggested. Thank you for being very direct, and thank you for describing this realistic landscape. You have addressed this topic of speed. So in this context, let's continue with Nadezhda Hryptievsky for us also to have an appropriate speed.
I do hope that you can hear me. I want to make a comment right away. I have been invited here today as a member of the Pre-Vetting Commission, although I'm also a member of the Third Commission. My colleague will refer to the Third Commission, but I will refer only to the activity of the Pre-Vetting Commission. It's a great chance to talk about it because on 7th of November the Pre-Vetting Commission mandate finalized when the last decision was issued on the decision issued by the Pre-Vetting Commission, and now we can make the summary of the activity. And yes, I will refer to this speed because the activity of the pre-vetting activity was a critical one. We have received a lot of criticism when the law was adopted. People had certain expectations, but the reality turned out to show that a qualitative evaluation takes time, much more than we initially have planned. The Pre-Vetting Commission was established in April 2022 with no previous experience doing this kind of evaluation. And during 17 months, the Pre-Vetting Commission managed to evaluate 67 candidates. If to compare the results and the period, then I would say that it was done quite quickly, take into account that we started from zero. We had 5 people in the secretariat of our commission, and we did all this job. Still, our activity led to a lot of public discussions, but it also allowed us to build the pathway for the other commissions, and also it helped us to understand what's the current state of play when it comes to ethical and financial integrity of the specialists. Unfortunately, we still had some unpleasant experiences. On 1st of August 2023, the Constitutional Court cancelled 21 decisions of the Pre-Vetting Commission. Just to give you some background, the Pre-Vetting Commission evaluated 69 candidates in total. 2 of them were evaluated in August 2023 in parallel with those evaluations that were renewed. 26 passed. This is 38% of the total number. So 9 of them were candidates for CSP and the others for SCM. The feedback was harsh. That was the first vetting process. although the fail to pass the evaluation did not negatively affect the career of those judges and prosecutors. Now, the decisions that were appealed at the Supreme Court, so out of them, only 2 of them were accepted. The others were renewed to be evaluated again. We had one evaluation that took 13 months, but that's mostly because of certain bottlenecks at the level of the Supreme Court due to that mass resignation period. So by February 2025, we examined 22 renewed evaluations, and by August 2025, we waited for the last decision. So we can see that the way appeals are reviewed. So for now, at least at the Court of Appeal, this period lasts shorter, and probably we won't have any evaluations that will last so much as previous ones. And the evaluations last a lot because as members of the Commission, we had a very big dilemma. So we had this prejudgment principle. So you cannot issue a decision unless it is very well reasoned. Therefore, it took us too much time. Now, those re-evaluation that shall be conducted by the Commission 2 and 3rd are the decision are linked to the decisions issued by SCM and SCP. We all make needed efforts to apply the law in a certain in such way to avoid these re-evaluations, but still these re-evaluations last a lot. Since today's topic is what comes after vetting procedure, I want to refer to what Mr. Karaman and Obada have stated. We need to understand what do we need to do next, and in order to do this, we need to make an evaluation, an assessment of the needs, challenges, and the pre-vetting commission identified a couple of problems that led to failure to pass the evaluation, and that's one reason is unreasonable wealth, and this is the accountability or responsibility of the National Integrity Authority. So they need to have a strengthened experience to make these assessments of wealth. So within the Commission, we already gained needed expertise, experience, and the methodology that we used within the Commission shall be overtaken by the Integrity Agency. SCM and SCP do not have such expertise in this field as the Integrity Authority. As a lawyer, I tell you, for me, it was something new to learn how to do all those calculations, how to assess the incomes, the expenses. So it's difficult to strengthen the capacities of the specialists in SCM and SCP to do all of this. It takes time, it takes money, it needs additional human resources to do all these financial evaluations. So I do hope that we will stop having only these declarations that are submitted and are not assessed in details. So it was a formal procedure. I want it to be stopped. Another problem that was highlighted by our commission was to use some unreasonable prices for buying real estate, other assets, and also unclear sources of income to buy those assets. The pre-vetting commission activity showed that this negative practice is widespread. People sign fake contracts just to hide the real price. Then I think that the Integrity Authority can do this, can evaluate it, and I think that when such contracts are in place with prices that are way different from the average price on the market, these contracts should be considered as a clear evidence. Unfortunately, we had many situations when we've identified many ethical issues among candidates and also major disruptions among SCM and SCP. As an example, there were many real estate programs under which prosecutors and judges were given with real estate, and many of them privatized certain real estate that had to belong to the state. Many legal provisions were violated in this regard. These benefits were used somehow to encourage, to motivate people, judges, prosecutors in the system, because they had very low salaries. But for the future, we need to provide fair wages, salaries, and if certain additional benefits are provided, this should be done according to the law. Even that land that is provided by the mayor's hall cannot be just given away to someone, but a clear contract shall be stated, and to make sure that citizens are not deprived and their rights are not violated. Unfortunately, when a judge, a prosecutor, or a lawyer does not pay taxes for providing certain services or having certain assets, how can we expect that ordinary citizens would do that? So these are a couple of issues that I have highlighted. When it comes to the judges' activity, we noticed that some of them violated the rights of the parties involved in the trial. They had conflict of interests with some parties. There was a case when a judge would judge a trial where the defense lawyer is someone that is clearly connected to him. Also, when it comes to the arrest, so there were cases when the arrests were prolonged with no clear reasons. So in this regard, the counsels to the SCP and SCM should be engaged more and tackle these things. So we need to learn from these experiences and to know what to do next. The main lesson learned by the Pre-Vetting Commission was the following one. If you need or you want to do a qualitative work, it takes time, it takes resources, and I agree with Mr. Karaman. You need skilled staff, very well paid, not only judges or prosecutors, but also clerks and other administrative staff shall be also properly remunerated. We cooperated with state institutions and private institutions. The Pre-Vetting Commission broke the ice in this regard. Thanks to us, the other commissions improved the methodology and the cooperation with other institutions to gather more data. We start to cooperate with more than 20 institutions, and now there are more than 50 institutions that cooperate with us. We are the first countries that improved very much the cooperation with banking institutions to get access to banking data. So it shows that banking institutions, financial institutions were opened to provide data. Yes, there were some that provided limited information or provided it with delay, but it's good that we experience this openness at the level of the society, and it's good to have this openness to build an judicial system that shows integrity and transparency. And another thing, to understand the complexity of this process, let me recall a recommendation stated by the Venice Commission. They highlighted that the pre-vetting decisions should not be published unless the consent is given. Unfortunately, due to that fact, there was a huge backlash among the public on this part. But the vetting decisions are published, anyone can read, and I want to end my intervention with one subject that is topical at the moment. It's the right moment to mention it. Any reform is impactful when it is implemented until the end. We are not yet finalizing the vetting process. Yes, when it comes to pre-vetting, we finalized it. The fact that now we have a full membership of SCM and SCP is the result of the activity of the Pre-Vetting Commission. But when it comes to vetting, we have two distinct systems, the prosecutorial and judicial systems. Now, for the vetting procedure, we covered only those subjects that have that are in higher positions. The prosecutorial system is very different from a judicial system. I'm not quite sure that if we evaluate only the Supreme Court, and Court of Appeal. It seems to me that no more than 50% of the judges at the Court of Appeals courts of appeal were evaluated. Now, taking into account these figures, so taking into account that only 30% of the judges were evaluated, shall we count on the impact of this reform? I don't think that we have a final answer to this question, but we should ask ourselves, because if we want an impactful reform, we should understand what's the current state of play and what did we do to reach this impact. Thank you so much. We will get back to the subjects that you have highlighted in the second part of our discussions. But now I will give the floor to Mr. Andrei Bival, the chair of the Vetting Commission. Could you please be brief? You have the floor, sir. Good afternoon. Thank you for introducing myself. My name is Andrei Bival, the chair of the Vetting Commission. Next to me here we have Mr. Marcel van der Velting and Mr. Rusu. They are members of the Vetting Commission. We started our activity in 2023, and our mandate was to evaluate the current judges and the ones that exceed in the position at the Supreme Court of Justice. The Parliament of the Republic of Moldova approved the Law 252. Thanks to this law, we received the mandate to evaluate the judges from the Supreme Court Court of Appeal. Also, we are responsible for the pre-vetting of all those candidates that submitted their membership to become members of Superior Council of Magistrates after the 1st September 2023. So, since September 2023, the Commission has 3 parallel processes with 3 and using 3 different laws for doing these processes. So we initiated 185 evaluation procedures. Following these, 65 resignations have been registered. 103 evaluations have been finalized. 64 of them passed, 39 didn't pass. The statistics shows that the Commission issued 1 report per week. From my point of view, taking into account the number of files that we had to evaluate, that's really good. At the moment, we have 11 pending evaluations and 2 re-evaluations. Now, the pass rate. So we calculate it based on all finalized procedures, because a procedure can be finalized through a resignation or a report issued by the Commission. Out of 168 evaluations, 64 passed, 104 did not pass. So 39 reports did not pass. These figures that you can see here are so you can see 64 reports passed, 48 resignations, 39 did not pass, and 17 files were cancelled. At the Supreme Court, we had 5 judges, acting judges in 2023, plus 45 candidates. Out of them, 3 passed the pre-vetting and they didn't need to be part of the vetting evaluation. 12 reports did not pass, 18 reports passed. Also, we had 5 subjects that cancelled their evaluation. At the moment, we have 5 ongoing evaluations. Now, when it comes to pre-vetting, we received 35 candidates from SCM and colleges. We issued 12 reports, according to which the subjects did not pass the evaluation, and 19 passed the evaluation. Now, courts of appeal. This is the most complex group of candidates that we have had. We had 76 subjects to evaluate, 63 acting judges, and 13 candidates. 39 resignations followed afterwards. It's almost half of it, more than half of it. One candidate passed pre-vetting procedure and did not engage in this vetting evaluation. Then we have 12 subjects who did not pass and 22 who passed the evaluation. When it comes to the first instance court, we had 24 acting judges. 10 judges resigned. Until now, the Commission issued 8 reports. 5 passed, 4 did not pass. At the moment, we have 2 pending evaluations that shall be finalized next year. This year, we've decided that it's the case to see the statistics of the candidates that were accepted. So in 2023, we received 24 candidates from Supreme Court, 12 candidates in 2024, and only 9 candidates in 2025. When it comes to Court of Appeal, we received 13 candidates from the Court of Appeal in 2024 and no candidates this year. And we didn't receive any subjects to evaluate. Those who would want to be part of any colleges of the SCM and members of SCM. Based on the workload that we are currently having, we will finalize 5 evaluations by February-March 2026. These are the candidates from Supreme Court. We have 2 more re-evaluations for candidates from Court of Appeal. They will be finalized in the first quarter next year. And we still have 6 procedures to evaluate the chairs and deputy chairs of courts. So there are 4 pending reports and 2 hearings that shall take place in the first quarter of the next year.
I address the issue of candidates because at least, based on the information that we have, there are 13 vacancies at the Supreme Court of Justice. 14, Mr. Gribincha corrected, 5 vacancies in the CSM collegiums, 16 vacancies at the Courts of Appeals, 15 vacancies in the Anticorruption specialized panel in Chișinău court, and it is not yet clear how many vacancies of presidents and deputy presidents of courts. So I believe it's more than 100 vacancies for which we have to assess at least one candidate, and this candidate should pass the assessment in order to fill in the vacancy. So this is a huge workload. We can only make some estimates, but we do not know how many candidates will apply or if there will be any candidates at all next year. So that would be it. I could just describe the challenges that we have encountered. Mrs. Hriptievsky has already referred to some of them. We have the same challenges, but I would like to highlight one. There is no exception from the secret of criminal investigation, and oftentimes we had the situation when we knew that a subject of assessment had a certain status in a criminal investigation. For example, the criminal case was opened in 2016 or 2017 or earlier, and it was still at the stage of criminal investigation, and this was invoked by the prosecution offices as a reason not to disclose the information. But we do not try to replace the prosecution, but oftentimes they have some information. We had cases when, on the basis of some files that were sent to court, we have identified certain ethical violations. To give you a simple example, registration or overhearing of some phone conversation between a judge of a court of appeal and a judge in a trial court. So the judge from the court of appeal was trying to find out information about a case that was at the first instance court, and one of the parties was the spouse of that respective judge. So this was a case of inappropriate interference that was not reported by any of the parties. That's just one example. Another challenge is that many of our subjects have double citizenship. They are also citizens of Romania, and we have very fragmented and problematic access to information from Romania. In particular, with regards to real estate, vehicles owned, and there is no way to find banking data. And this is a challenge because many of them report in the National Integrity Authority social benefits from the Romanian government, and we can assume that in addition to that they might have some properties, financial assets in Romania, but we do not have access to this data. We can only use open source data. Another challenge, but this is not a challenge of the Commission only, I think this is a challenge of the whole system and of the governance, lack of candidates, because the time span is 31st of December 2026. After this date, our work will not be extended. And during this year, we need to manage to assess a sufficient number of candidates in order to be able to fill in at least, so that's my personal opinion as legal professional and citizen of Moldova. So I believe that we need to manage to assess a minimum number of candidates for the Supreme Court of Justice and Courts of Appeals. Regarding the crazy idea of Mr. Obada, in theory it's possible, it's also possible in practice, but we have to discuss the priorities. Our commission focuses on judiciary, so as long as in the judiciary there are so many vacancies for which candidates have not been evaluated, for me it's difficult to accept this idea of starting to assess the prosecutors and not to finish the assessment of judges. But in the end it will be a political decision. So we will comply with the laws on external assessment. Thank you. Thank you. That is why we are having this discussion, in order to be able to impact this process, in order to be able to influence the content of laws. And now let's continue with Virginia Moraru, Deputy President of the Commission for the Assessment of Prosecutors. Thank you. Good morning. I would like to welcome all of the participants in this event, and I would like to congratulate and thank the organizers for the invitation to participate in this forum. and I believe that this is the first presence of the Commission in front of the public after a long period of time to present the outcomes. Of course, our outcomes are a bit more modest compared to the vetting commission for judges, but we are progressing. Our situation was impacted by a number of circumstances that were beyond the control of our commission and other stakeholders that are involved in this reform, which is very ambitious and very complicated, considering the plenty of circumstances that occur every day, from human factor to other events happening either regionally or internationally. I will start with some brief historic data about the Commission. Of course, it's always difficult to present the activity of the Commission after Mr. Bivol, representative of the Commission evaluating the judges, but I will try to do it. So our commission was established by appointing 5 members in November 2023, and from the very beginning we were short of 1 national member, and the mandate of the commission, according to Law 252, the mandate of the commission is to conduct the assessment according to the provision of Law 26 for candidates to positions in collegiums of CSP, as well as the prosecutors listed in Article 3 in the law, where the criteria are much more complex compared to criteria used for judges. Speaking about the membership of the Commission, so on November 23rd, we had 5 members appointed. In February 2024, the 6th member was appointed. Then in April, a member resigned. In May, another member was appointed. And the last very important issue are the legal amendments, which introduced a new panel consisting of 3 people. And unfortunately, we have a less pleasant situation. So we're short of an international member in the Commission. Another important aspect that impacts its work is the Commission's Secretariat, which is the support unit. And for a long period of time, it was our vulnerability, considering the limited number of staff with which the Commission started its work in December 2024. Back then, we had only 2 analysts who collected and processed information and data for purposes of assessing candidates in collegiums subordinated to the Super Council of Prosecutors. We had communication with judiciary stakeholders and with the Super Council of Prosecutors, and as a result of these discussions, in 2024, we focused on the assessment of candidates for positions in the collegiums subordinated to the Super Council of Prosecutors. And after that, as a result of pressures to implement the reform as quickly as possible, we were mandated to assess the priority subjects stipulated in the law, meaning the prosecutors in the Anticorruption Prosecution Office, and then continuing with all of the others listed in the law, to provide some general statistical data, which are not final data for 2025. So, as of now, we have 190 prosecutors who were notified about the fact that the assessment was started on the basis of Law 26 and Law 252. When starting the assessment on the basis of the notification and request to fill in and submit to the Commission the needed documents in order to be able to start the data collection and review, 26 prosecutors resigned because of various reasons that were communicated initially. 50 processes have been completed. Or, in other words, the assessment of 50 prosecutors have ended, and this includes both candidates for the positions in collegium subordinated to the Superior Council of Prosecutors, as well as prosecutors for which the assessment was terminated because they promoted the vetting on the basis of law number 26 or failed the assessment on the basis of other laws. And now we have 113 ongoing processes, of these 113, we have 7 reports in the hearing stage, 7 reports being prepared now, and 2 hearings planned for this Friday. And one of the subjects coming to this public hearing was already evaluated and heard, but considering the deficiencies in the approval of the report or divergences in the approval of report, because the law stipulates clearly that the assessment report shall be approved with the unanimous vote of members. The report was submitted back to the Commission for re-evaluation, so we will have the first case in our practice of that was moved up to the Commission from the panel. When speaking about outcomes, we break them down by groups of prosecutors because they are assessed on the basis of different laws. So, as I've said, 2024 focused on the assessment and the completion of the assessment until December 2024 of the 32 candidates for the position of members in collegiums. Of them, 15 passed the assessment, 11 candidates for the collegium for selection and evaluation of prosecutors, 3 candidates in the collegium disciplinary and ethical collegium, and 1 candidate for positions in both collegiums. Of them, out of 32 prosecutors, 17 failed the assessment, and I would like to draw your attention to the first figure, 9 prosecutors who, in my opinion, and on the basis of our discussions with the colleagues, we have reached the conclusion that this is a too high number. 9 prosecutors who failed the assessment because of ethical and financial integrity criteria. So their professional and personal lifestyle generated gaps and deficiencies which resulted in their failure. Like Commission number 2, in this group of prosecutors, we have 4 prosecutors who failed the evaluation because they have either failed to submit the requested documents when starting the evaluation, and 3 of them withdrew from the competition, and according to the law, they are regarded as failing the assessment, the vetting. The biggest challenge for Commission was the following. We worked during 1 year with a high turnover of Commission members. We had a shortage of staff in the Secretariat. And another challenge were the appeals of failure reports. We had 11 appeals submitted to the Supreme Court of Justice, and It's important to note that the court upheld all of the 11 failure decisions, and in more than 80% of the cases, the Commission's arguments were taken into account. And we see this as a sign of quality of our work. We see it as a sign that our work is objective and fair and impartial. The second component is our assessment done on the basis of Law 252. And the first group of subjects who were notified according to the provisions of Law 252 are the anti-corruption prosecutors, because the law stipulates that they are the priority group for assessment. In 2024, we notified 67 prosecutors, of whom 10 resigned within the following 10 days. And one was suspended due to a criminal investigation. So we had a communication with the Superior Council of Prosecutors and with the General Prosecution Office, who informed us that that prosecutor left the country, so it was not possible to notify him. As of now, we have 17 anti-corruption prosecutors who were assessed. For them, we have 3 decisions to terminate the vetting process, because 2 prosecutors from anti-corruption prosecution passed the evaluation on the basis of law number 26. We have 3 failure reports, of which 2 were challenged. Well, actually, they were not the report were challenged, but the decisions of the Superior Council of Prosecutors were challenged. But these decisions were issued on the basis of failure reports. One decision was upheld by the Supreme Court, another is still pending at the Supreme Court of Justice. And we have another failure report which was sent back for a reassessment on the basis of a decision issued by the Superior Council of Prosecutors. And we have 11 passing reports. They were finished and submitted to the Superior Council of Prosecutors. Now we have 39 evaluation processes ongoing at different stages. So, as I've said, 7 reports are being developed now. 3 of them have to be approved this week. We have 2 planned hearings. We have 30 subjects that are being analyzed now at different stages, and 2 subjects in process of reassessment. For one of them, we have a passing report, and another one has a failure report. Another group of prosecutors that needs to be evaluated in 2025 is the list of chief prosecutors in the General Prosecution Office. One was sent for assessment in 2024. So overall, the number is 13 prosecutors from the General Prosecution Office. As a result of notification, 2 prosecutors resigned. 1 deputy general prosecutor. So for him, the assessment ended, and we have a decision of the Superior Council of Prosecutors issued. For 1 prosecutor, we are working now on the report, and it will be approved as soon as possible, and 9 of them are being assessed now. So please move to conclusions. So we have a specialized prosecution office, Cox. There we have a high number of prosecutors that were notified, but based on the figures that you can see on the screen, 63 prosecutors are being assessed now, and the assessments are supposed to be finished in 2026. additional estimates for chief prosecutors and their deputies from the territorial prosecution offices. About 72 prosecutors need to be notified. An additional assessment considering the 3 vacancies in the disciplinary and ethics collegium. And as far as I know, the Super Council of Prosecutors has already started the competition. I don't know whether it's the first one or it's a repeated one. We don't know yet how many candidates will have to be evaluated for that purpose. Our challenges were plenty and were big, starting with the insufficient staff and the trends of the former funder of the secretariat, but these challenges were overcome because now we are being funded by other development partners. And using this opportunity, I would like to thank representatives of the Netherlands and EU delegation who stepped in quickly and efficiently, and with their support we managed to recruit the needed staff, because this is the main support that the Commission needs in order to be able to progress quicker. We had 3 rounds of recruitment for secretariat staff. We had more than 400 applications, more than 100 interviews held, 49 or 50 requests for assessment, and only 14 persons were employed, considering the circumstances highlighted in the candidate assessment reports. But a challenge that is still in place is the shortage of time, considering the fixed deadline, December 2026, and the huge number of subjects to be assessed. Another challenge is the very complex cases because of various reasons. Be it the huge volume of information that we accumulate, the number of entities that we need to contact in order to request information, as well as resistance within the system, in particular from the Anticorruption Prosecution Office. My colleagues will confirm that. But we gradually have managed to overcome these challenges, including the resistance among assessed subjects who provide very vague responses when we ask for information or clarifications. Another important and difficult aspect is the presence of European Court of Human Rights decisions, because the situation is a bit more complicated for our commission compared with Commission number 2, because we also ask for the case files in order to understand very clear what actions or documents issued by prosecutors resulted in Moldova losing the case at the European Court of Human Rights. So this is just a couple of challenges. It's not a comprehensive list, but in the end I would like to refer to a statement made by Mrs. Kövesi in Moldova, who said that we Romanians overall are the nation who are always complaining that we don't have this, we don't have that. But actually what we have to do is to mobilize ourselves. We have to start working hard and achieving our goals. And I am glad that we are at a stage when we have started to work hard in in order to achieve the goals that have been set. And the last statement, whether vetting was needed or not, well, actually that's not a question. I want to tell you that considering my previous experience of anti-corruption officer, vetting is the most ambitious prevention measure, which for sure, like any corruption prevention measure, should be continuous. So this task will have to be taken over by the Superior Council of Prosecutors and of Magistracy. And I'm very glad that we have a very good cooperation now, and we've had it from the very beginning with our colleagues from the Superior Council of Prosecutors, considering the discussions that we have with them in order to have common approaches, in order to share experience and knowledge, and in order to avoid another possible challenge for the CSP to submit back for reassessment our reports. I'd like to thank my colleagues for their support and for their openness, and I'd like to thank all of the colleagues who participate and invest efforts for this very complicated reform. Good luck. Thank you, Mrs. Moraru. We have a speech from Albania. Hopefully, Mr. Admond Ahmeti has connected already online, and I hope that he has heard us and listened to the previous speeches.
Good morning from Tirana. Dear honorable panelists and participators, dear Mrs. Liliana, thank you for invitation in this forum. I will give firstly some elements of Albanian justice reform country context. At the end of 2014, the Assembly of Albania established the ad hoc commission to design far-reaching justice reform, including the main legislative term. This led, among other things, to amend in 2016 the third of the Constitution of Albania. And these changes in our constitution was very big and was very important in the context of our country. These changes addresses issues related to judicial independence, accountability, integrity, efficiency, and professionalism. Enabling laws were enacted or amended shortly thereafter. The reform made substantial institutional changes, including the establishment completed in 2018 of two separate bodies, the High Judicial Council and the High Prosecutorial Council, the High Inspector of Justice and the Justice Appointment Council. The High Judicial Council is the only body in Albania mandated to carry out disciplinary investigation of judges and prosecutors and propose disciplinary action. The High Council, Judicial Council and the High Prosecutorial Council decide on disciplinary measure respectively. In 2016, judicial reform in Albania led to profound of the legal and institutional framework of the judiciary and prosecution services and aimed of putting in place legal guarantee to strengthen the independence of the judiciary and prosecution, including unblocking mechanism for the appointment of judges and prosecutors, tools to avoid political influence in the justice institution, accountability mechanism, and the vetting of all sitting judges and prosecutors in line with the European standards. The aim of the vetting process was to fight widespread corruption, ensure unprofessionalism, and eliminate links with organized crime among judges and prosecutors, establish an independent and impact judicial system, and restore public trust in it. The involvement of the international community was considered crucial for the credibility of the process anchored in the Constitution, whereas note that the vetting process would create a significant tension within a country judiciary, the Venice Commission of the Council of Europe considered that its temporary nature was justified given the cumulative fulfillment of the following circumstances. The level of corruption and political influence in the judiciary was extremely high in Albania. The process measure enjoyed broad political and public support, and the existing tools and mechanisms to ensure integrity and fight corruption of judicial office holders has been exhausted. For those reasons, the Venice Commission was concluded that the vetting process was appropriate for the reform process and that it would be pursued through until completion under the continued close and independent supervision of the international monitoring operation, described more fully below. For your information, international monitoring operation was a body that was created by the USA and the European Commission experts that are in monitoring all of the process of vetting in Albania. Because, as you know, we love American more than any other nationality. Thus, as part of this justice reform, Albania introduced a comprehensive vetting process for all sitting judges and prosecutors. This also covers senior legal advisor and assistant, and upon request, former judges or prosecutor and former legal advisor of the Constitutional Court and High Court. Under this part of the judicial reform, the vetting institution, including the Independence Qualification Commission, 2 public commissioners and the appeal chambers, have since 2017 been concluding and the reevaluation of sitting judges and prosecutors. This process includes the examination of their assets, their professional standing, as well as the possible connection to organized crime. The vetting pertains to 3 pillars of assessment: proficiency assessment, asset verification, which include the health and assesses and their close relative in Albania and abroad, and the background assessment, including links to organized crime. The vetting process is nearing its end under the independent external oversight of international monitoring operation, which consists, as I said, with the European Commission and the USA State and Justice Department. Under this body supervised process, the vetting has delivered substantial result towards eliminating persons from the system whose health ties to organized crime and professionalism are in doubt. As highlighted by the Venice Commission, the main elements of the structure carried out the process of the vetting were threefold. The independent commission was composed of independent and qualified personnel and had the necessary investigative and decisional powers to carry out its function. The appeal chamber was set up as a court of law and acted as an independent tribunal responsible for examining appeals against the decision of the independent commission of question of fact and law. And third, the international observers of the international monitoring operating were in a position to monitor and report the vetting process in complete independence. No further appeals to domestic Albania court was permitted, but appeals to European Court of Human Rights are specifically mentioned as the next capture the appeal chamber. The Venice Commission submitted that the vetting process provided sufficient guarantee for concluding a due process and respecting fundamental rights for the following 4 reasons. Firstly, the legal framework named in my presentation in the Article 179.b of the Constitution and Section 6 and 5. The Vetting Act laid down principle to ensure respect for the right to a late hearing and for the fundamental rights of a person to be evaluated. Second, both of the Constitution and the Vetting Act gave far-reaching independence to the vetting bodies. The appeal chambers was attached to a constitutional court, and the Independence Commission members enjoyed the status of Supreme Court judges. The Constitution and the Vetting Act granted them a high level of personal protection against threat of life, health, and property. The members of the vetting bodies were subject to disciplinary proceeding, which, for the sake of avoiding undue external pressure, would be carried out by the appeal chamber. Thirdly, the legal framework provided for the right to appeal against the independence qualification committees findings to appeal chambers, which was the only judicial body responsible for examining appeals on question of fact and law. The proceeding before the appeal of chambers was governed by the provision to the Administrative Court Acts. And fourthly, the establishment the role of the International Monitoring Operator, the secretariat of which was funded by the European Commission, provided important additional safeguards for ensuring respect for the right to a fair hearing and fundamental rights. The European Commission, in the country reports of recent years, 2021 and 2024, appears that Albania is moderately prepared on the functioning of the judiciary and legislatively and institutional framework of judiciary has a high level of alignment with the EU acquis and European standard. The Albanian institutions have been fully engaged in advancing the implementation of the most comprehensive and unprecedented reform undertaken in the country's justice system. Since its inception, the justice reform was aimed at meeting the highest attainable standard of the acquis in the area of rule of law. For your information, the European Commission assessment in the country report for 2023 said that good progress was made during the reporting period with the continued implementation of justice reform. The vetting process for judges and prosecutors has advanced with overall good result, through the pace of proceeding in appeals need to be stepped up in the fight of the revised constitutional deadline with regard of the quality of the process. In January 2024, Albania was invited for the first time to contribute to the rule of law report. Generally, the assessment of the European Commission was positive. The vetting process for all judges and prosecutors has strengthened accountability. In May 2024, the appeal chamber imposed a 15 years ban from position of high judicial office to the chair of the High Prosecutor Council. The international monitoring operation deployed by the European Commission in operation with the United States oversees the vetting process. This body issued 38 recommendations for the appeal, and 12 dissenting for occurring opinion after the final decision. This is our map of institutional framework in Albania of vetting process. The first instance decision is the Independent Qualification Commission, that is the main vetting body that has concluded, has finished their work in Albania. Appeal chamber is mandated by the Constitution and vetting law to conclude their work in 2016 in the May, and two other special appeal chamber and the monitoring international monitoring operation.
Edmond, can you speak two words of conclusion, please?
Okay.
Okay.
This is the fact and figure. For my conclusion, I will suggest for for Moldova colleagues, my modest opinion that first, Moldova should keep in mind the vacancies that may be created by the vetting process. In Albania, this part should have been better specified in the constitution and the vetting law, so that during the vetting process of judges and prosecutors, more concrete measures be taken to increase the number of a new magistrate in order not to create stocks of trial files. Moldovan citizen will not applaud as Albanian citizen too. The result of the vetting, the judges and prosecutor will leave, but the bet is that may remain in how flexible and prudent you will show in order not to create vacancies and not to train competent magistrate with integrity without at all compromising the equality and professionalism, which could collapse the judicial power. For us, this is the bigger challenges, challenges that is taking more time that was anticipated in the initial stages of setting up the vetting process. As I heard before, Mr. Bata mentioned that the process of appointment new prosecutor requiring time to comply with the rules for their appointment. My suggestion in this case is that in the initial stage, you should take the necessary legal provision to regulate the transitional period for removals from vetting, since the further the process progresses, the more the impression is created that the vetting process without first ensuring the transition is a risky and in some cases even unfair process. In the final phase of the vetting process, a process that ends with the appeal chambers in June 2026, many professionalism and many citizens of the profession in the field who were very optimistic before about the vetting process at the beginning of this process now are very skeptical and think that the vetting process had caused more harm than good due to the delays trial, especially in civil and administrative. As I heard for you, honorable panel, of the main leaders of the judiciary in Moldova and the head of the vetting bodies, it seems as if the same deja vu was appearing as in Albania. At the beginning, we show the figures of judges and prosecutors who don't pass the vetting process, and this tastes good for the process of creating an honest and integrity judicial and prosecutorial body. But the more the process goes toward to the end, as in our case, no one wants to mention this achievement expressed for international reports and donors of justice reform, but the problem arises as to when the backlog of files will decrease and whether or not the new magistrate are up to the task of providing speedy justice and according to European standard. This is my first suggestion. The second, my task, the suggestion task for me is to pay special attention to civil justice, because vetting and citizen expectation are not only focused on criminal justice, but mostly want to have a speedy justice in civil and administrative jurisdiction. The third, in parallel, what our international European Commission said to us that during that you are judging and concluding the vetting process for Albania was duty that all cases that was problematic to refer cases to the prosecutor office in cases where the subject of the vetting are suspected of having inappropriate contact and having illegal assets. This is our duty in the end of this process, and
thank you.
That's all. I have.
Thank you. Thank you very much. Stay with us. Iar noi o să continuăm. Am ajuns la.
We will continue. So we are almost ending the panel of discussion. We will have a Q&A session right now. We have around 15 minutes for this Q&A session. We will see whether the organizers will allow us to exceed this time. If not, then we will stick to these 15 minutes for a Q&A session. Please address the questions to our panelists, but before you do, I have a question for our panelist. Madam Hryptievsky was saying that it's not right and it's not fair that not all judges in the system are evaluated, but Mr. Bivel also has highlighted that there are no sufficient candidates, and I'm asking you, so maybe this lack of candidates is justified mainly by what Madam Hryptievsky has said. If I'm a judge in a court, then I would wait until January 2026. And afterwards, I will think maybe they won't be the case for me to be part of this vetting process. So my question is the following one. How should the legislation look like in the future to tackle it? Let's start with this question. So I'm looking forward to your answers. Mr. Karaman, please. Thank you, Madam Liliana. It's a good question. Should we evaluate all the judges in the system? Let's get back to the stage when we started the pre-vetting and vetting, and let's recall what was the foundation for this process. To do the pre-vetting and vetting in Moldova, we had a couple of very well mediatized and promoted decisions that were taken. This was the first reason. The second reason to do vetting and pre-vetting was the low trust in the justice system, inefficient mechanisms in place, and the inefficiencies of those collegiums. All these reasons put together made us want to change and start these pre-vetting and vetting processes to evaluate the future members of ASEAN, collegiums, Supreme Court of Justice that had to be evaluated in parallel with those candidates that wanted to be part of ASEAN. Afterwards, we decided to evaluate the judges within Court of Appeal, the chairs and the deputy chairs of Courts of Appeal. So today we have the same reasons that allow us to justify the need for pre-vetting and vetting processes. 3 years ago, the situation, the context in Moldova was totally different. Now we have the Superior Council of Magistrates that consists of members that passed pre-vetting. So there are no doubts that these people are doing their job honestly and with integrity. Also, we have many judges, acting judges now, that also passed pre-vetting process, and they continue to do their job well. So we improve the justice system in the Republic of Moldova step by step. We can see an improvement in the quality of the Justice Act. We see that the high mediatized cases are better tried, and we can see improvement in the public trust. So the Superior Council of Magistrates can no longer activate with or operate with specialists that have not been part of that pre-vetting process. What we should do next is to strengthen the capacities of auto-administration body. We need to strengthen the capacities of collegiums. We need to build a mechanism that will allow us to at least do the financial evaluation of those judges from the first instance court. But we need to do it step by step. So the evaluation of the first instance court judges shall be done step by step. To avoid a negative impact on the activity of the first instance courts. We've seen the consequences of the vetting process for the Supreme Court of Justice. Well, thanks to legal provisions, we had the chance to temporarily transfer the judges from lower courts to the Supreme Court of Justice to cover that staff turnover and the gaps until the vetting process is finalized. At the moment, half of the jobs are available at these courts. As the report has highlighted, many judges decided to resignate when they became subjects of the vetting process. These available jobs shall be fulfilled with judges from the first instance courts, and our biggest concern is that the judges from the first instance courts that are eligible to fulfill those available vacancies, if they are informed to be the subject of the vetting process, they will participate, but we won't have the same situation as it happened to the Supreme Court of Justice. We should manage this thing. The Superior Council of Magistrates is in a very tough situation. On the one hand, we support the vetting process at the level of the Supreme Court of Justice, Courts of Appeal, but on the other hand, we are the ones that shall make sure that the system functions well, to avoid this situation when we do not have people in place. we should continue the vetting process for the subjects that are included in the law 252, but judges from the first instance courts shall be evaluated by the Collegium of Evaluation and Designation according to the schedules established. And the other judges of the Supreme Court shall be part of this vetting process. Thank you. We received a question on WhatsApp. So, at the Supreme Court of Justice and Court of Appeal, there are many vacancies. So what would you do in this regard when you do not have enough judges that were evaluated to fulfill these vacancies? Well, first of all, we need to make sure that the position of a judge is an attractive position. We observed that even judges at the first instance courts didn't want to be promoted to the Supreme Court of Justice. They do not apply for these very prestigious jobs, and this is a concern for us. It says a lot about the fact that the position of a judge at the Supreme Court of Justice is not attractive for them. People from lower courts do not want to be promoted to higher courts. The same goes for the vacancies at the Courts of Appeal. The workload at the Courts of Appeal are tripled compared to the other courts, and the salaries are not much different compared to the salaries received by the judges at the first instance courts. What we should do? Well, we should increase the attractiveness of these jobs. During the next year, we will do it together with our partners and the National Justice Institute. Thank you very much, Mr. Karaman. If there is anyone in the room who has a question, so please let me know. But we also have another question received via WhatsApp for Madam Hriptievsky. You mentioned that many years ago you mentioned that just a miracle could help us to finalize the vetting process by 2026. So could you elaborate on them, on this statement? You noticed the figures presented by my colleague today. The number of the subjects eligible for the evaluation used to be higher, 190 up to now, plus 72. So there will be around 250 candidates. That was our initial task, to evaluate them. In 2023, in November 23, the commission was established. Since we did not receive sufficient support, we didn't manage to achieve much. We need to be realist. We shall finalize this process in 2027. If the judicial map is changing and the number of courts will be reduced, then we will have lower number of subjects to be evaluated. To evaluate all of them by the end of 2026, we need to increase our staff by 1/3. But the most important thing is to have subjects that cooperate with us and to have less decisions sent to re-evaluation. So when I mentioned the miracle, we need a miracle, I refer to these particular things. We make our best with the resources that we have. I cannot explain to myself one particular thing, but if you look at the statistics concerning the judicial sector, you will see that we had 40% of resignations. In prosecutorial sector, less subjects resigned, but in judicial, the number is very high. It's crucial to ask ourselves, so I do understand that we need to speed up, but let's focus on quality. I don't know how about others, but I personally I've watched recently the documentary posted by Recorder news outlet, a Romanian investigation journalistic agency. And after watching it, I have asked myself, this lack of candidates is justified, or it's just an expectation that vetting will end and things will continue the way they were? Or maybe some candidates just expected other results of the elections. They were expecting that once the results of the elections are different, the vetting process will be stopped or changed. I don't know. Also, it's important to mention another thing. The vetting and pre-vetting was promoted negatively among public by certain actors that considered this process to be not useful, not needed. But the process is fair. The law 252 provides a provision according to which if a person registers difference of 234,000 lei between the income and expenses, still that candidate will pass the evaluation. And that's the reason. The reason for that is that over the years we had different prices. We had different provisions to report the expenses and income. We should understand that the criteria included in the law 252 are not so harsh. This exercise, in the end, will allow us to exclude from the system those people that indeed seriously violated the laws. Yes, indeed. Maybe there were cases when certain candidates were right, but they couldn't prove, they didn't have any evidence to prove their statements. And once again, to have a good impact, we need to finalize the reform. Thank you so much. We have another question in the room. Please. I want to take the floor. I want to comment on the process that is expected to be finalized by 2027. Well, First of all, it takes time because the Commission focuses on the quality of the evaluation, and also they deal with complex materials that shall be assessed, analyzed, and it takes time to identify needed solutions on daily basis to increase the number of evaluated candidates. Therefore, the statistics that we have shown is changing regularly each week, each month, and so on. Also, we intend to recruit more specialists, to have a higher number of specialist analysts that will prepare the reports, case file materials for the evaluation of candidates. We will need at least to increase the number of our staff at least by 1/3. So we do hope that these processes will be implemented on time, but objectively. And one thing more. I encourage the non-governmental organizations that work in human rights sector to be engaged. They should provide additional information and to inform citizens about these processes. Also to share the information that they have on certain decisions issued by the candidates, so we could have a clear picture and we could have in this way comprehensive information that will allow us to take a good decision. Mr. Obado, just a short comment, brief. SCM and SCP is accountable for approving or disapproving the reports that are submitted by the vetting commission. So we are the ones to vote in favor or not. Therefore, as I've mentioned, the Commission has the investigation skills and capacities, but we do not have. And in this regard, I'm questioning whether do we have the needed experience, do we have the needed expertise and capacities to approve or disapprove these reports. Of course, our experts that are designated help us a lot. We also need to take into account the risks and gaps experienced by our Albanian colleagues to avoid these things. We, as Mr. Karaman has highlighted, all those subjects shall be evaluated, and afterwards we need to build up our own capacities to continue to do so afterwards. You need to understand that citizens are not aware of what is going on. We need to clarify things. We need to increase our capacities, and when the commissions will end their activity, we should use the experience and the expertise of the secretariat of those commissions. We need to engage afterwards these analysts and experts to help us afterwards. Mr. Yakimovsky, you have the floor. Please be brief. I will be very brief. I have two questions that are linked to our subject, what happens afterwards. The first question, there are two judges that passed the vetting. Now they apply to be members of SCM. One of them supported a pre-vetting procedure. The other did not support. Who has the highest chance to be member? Now, the second question: someone who did not pass was not subject of the vetting process, but does he have the right to evaluate the report submitted by the vetting commission? When it comes to the first question, well, if there is a judge that shall promote the integrity of the institution that he represents, or a prosecutor wants to lead a prosecution office with integrity and honesty, then we should support that judge or prosecutor that supports the vetting procedure, because this is about integrity. This is a process that allows us to increase the trust, the public trust in our institutions. But if two judges passed the vetting procedure and they want to be not in administrative positions, but they want to be members of the SCM, then we need to take into account their professionalism, their competencies, but also the fact that they support this vetting process is an advantage, because only in this way their institution will be fully functional. Can I make a comment on what Mr. Obada has said? What do we understand by vetting and what comes afterwards? I do understand that when the vetting started, indeed, that's something exceptional that takes place only once. But now we are discussing the fact that how this process will be continued and who will continue to do it. Can judges of first instance be engaged? Well, if they want to continue to do this afterwards, like to be part of this evaluation afterwards, then for now they should be evaluated. We should avoid this chaos in the system. Or maybe I did not understand your point of view, I don't know. When the commissions started, the first commission had 67 candidates, and it took it 17 months to evaluate these candidates. So it's a very complex activity. When it comes to what happens afterwards, then this methodology could be taken by the experts at the Collegium of SCM and SCP. So our collegiums did not have enough competence and skills to do the evaluation of the professionalism of the judges and prosecutors. We discussing two distinct things. Yes, indeed, when we all started, we were very ambitious to evaluate 100 candidates in a year. But we realize that despite all these delays, we are still managing to do a lot in a short time. So yes, it took us 2 years, and we will need 2 years more, but we will finalize a comprehensive exercise. Thank you so much. We will get back to the conclusions, but we have another question. Vlad Gheoribincha, the Supreme Court of Justice. I didn't have any plan to intervene, but listening to you, I have a couple of short comments. One, I was surprised to hear that prosecutors do not want to share the information with the Commission, because according to the law, all prosecution's offices are obliged to present the information needed for the Commission. If someone says that the Criminal Procedure Code does not allow them, then, from my point of view, those specialists do not understand the provisions of the Criminal Procedure Code. Two, if the Supreme Court of Justice is required to provide more guidance, please let us know. I am a member of court, and we can provide needed support. We do have a problem concerning the reasoning of the judgments, but we are working on it. I do hope that in January, February, all the decisions will be issued in time. Three, the workload of the commissions is huge. But I'm pretty much sure that your secretariat is much bigger than the secretariat of SCM and SCP. I don't understand how SCM and SCP will do such evaluations afterwards. Plus, the National Authority of Integrity should have the same methodology, and should evaluate everyone in the same way, not differently, because otherwise we will create parallel systems, and we not allow the SCM and SCP to focus on their clear mandate to provide efficiency in the work of prosecutorial and judiciary system. Okay, now we will move to the conclusions. But do you want to comment? Yes, I want to comment on what Mr. Gheoribincha has said, and to conclude the presentation. The Commission submitted many requests to APO. APO refused to provide information, and they referred to the provisions of the Criminal Procedure Code. And we afterwards sent the request to the General Prosecution Office, and we did not receive any information. We asked the former Prosecutor General, who is now at the Supreme Court of Justice, and the current Prosecutor General, that did not provide any answers to our request. At the same time, we do understand that the Superior Council of Magistrates, at least in this particular context, does not have a secretariat and qualified staff to provide financial integrity evaluation. And I do agree with Mr. Gheoribincha, we do not need to double the competencies. I think that the National Authority of Integrity shall overtake the methods and methodologies of the commissions, and to apply them when they are doing the integrity evaluation of all subjects. Afterwards, the collegiums could request the reports from ANI I'm pretty much sure that collegiums have needed skills and expertise to do the ethical integrity evaluation of the subjects, but not the financial one. I think it's already the time for the Superior Council of Magistrates to decide what to do next. Do they have the possibility to use the human resources that were skilled, trained, to use these human resources within their collegiums? So the Superior Council of Magistrates should have this discussion with the government and with the development partners to know how exactly to engage these human resources and to avoid additional cost. Mr. Karaman spoke about the attractiveness of these vacancies. I personally believe that the salaries of judges at the Supreme Court of Justice and Courts of Appeal shall be more attractive, shall be increased in a way to be more attractive. In this way, judges will be motivated to participate in vetting process, because I do understand the vetting process is not something comfortable or a comfortable procedure for them. And of course, it's somehow convenient for many judges to say they will wait until the process will end. I do understand that many candidates expect the end of this procedure to avoid being evaluated. Now, Mr. Could you mention whether you are ready to overtake the expertise and experience of human resources developed within the commissions? I do believe that some judges were evaluated by collegiums. They were positively evaluated by collegiums not because the secretariat was not working well, but because now the situation is different. I'm pretty much sure that the members of our council and our collegiums are ready to do a better job when it comes to the ethical evaluation, and I'm pretty much sure that ANI, the National Agency for Integrity, is more capable to do the financial evaluation of the subjects. One thing is clear. At the moment, our secretariat is not, and it does not look like the one the Commission has. And even after the commissions will end their activities, the secretariat will not look like theirs. But it doesn't mean that we should have, it doesn't mean that the vetting process should last longer than we planned. I do believe that the Council can overtake the evaluation procedures step by step and can strengthen step by step the justice system. Mr. Obada was talking about these interim positions in prosecution's offices. It's similar in the judicial sector as well, because we all want some stability in the justice sector. At the moment, we have a Collegium of Evaluation and Selection that is active and helps us with the selection process. But besides this, candidates shall be evaluated, and probably that's the reason why we have 0 candidates, because according to the law, the council will launch the competition and afterwards will designate the subjects to the commission to be evaluated. We all know that it took us time to make this collegium operational, and indeed the members were not subject of the vetting evaluation. We do have candidates that shall be urgently evaluated and some candidates that shall be evaluated even faster. So for now, we do the vetting for Supreme Court of Justice that is done at the moment. Could you be brief and conclude your message? Next year, the Council should have a clear picture of what will happen after post-vetting. I do hope that the members of the Council and the entire society will see the results brought up by our Collegium, and we will prove that the Collegium has the capacity to continue to evaluate the integrity of the people in the system. Thank you so much. And for now, I kindly ask you to take a break. We will get back at 11:45 and we will continue with another panel of discussion. Now I thank the speakers.
Doamnelor și domnilor, Forumul Reformarea Justiției și Combaterea Corupției va începe în 5 minute. Vă rugăm să vă pregătiți să luați loc în sală. Stimați participanți, vă invităm să luați loc în sală. Forumul Reformarea Justiției și Combaterea Corupției va fi reluat în 2 minute. Stimați participanți, vă invităm să luați loc în sală. Forumul Reformarea Justiției și Combaterea Corupției va fi reluat în 30 de secunde.
Da, Da. Bună ziua, doamnă.
Good afternoon, ladies and gentlemen, dear audience. It's a pleasure to welcome you at the new edition of the Forum on Justice Reform and Fighting Corruption to discuss the most topical subject, anti-corruption, fighting corruption. Before inviting the panelists, we will have an introductory speech, and I will give the floor to our colleague from LRC for speech. We had a constant fight against corruption for the past year. All the governments for the past 20 years promised that they will come to power to fight corruption that they inherited from other governments. It happened only once, when that promise to fight corruption won the elections in our country. And not only once, but twice. We had presidential elections in 2020 and parliamentary elections in 2021. The promise made by the party and the candidate elected, that promise was that they will fight against corruption. At the beginning, everything was clear what combating corruption means. The priority is to combat the biggest corruption, to hold accountable those who deprived the state the most. But afterwards, the narrative has changed, especially when the war in Ukraine started. The government considered that the electoral corruption shall be a priority. And this opinion is also shared by the majority of citizens. But there is opposition that considers that the priority for the state is the fight against corruption that deprive the state from the public money. We've discussed a lot for the previous years. We saw how the law enforcement bodies changed, amended. Also, we had public scandals in the public, especially last year. We almost ended up to have an open war between the state and the Anti-Corruption Prosecutor's Office. Who won and who lost? Today, we will discuss this topic during our panel that I have the honor to moderate. But before inviting the speakers, I want to ask our colleague, Victoria Meriuța, to present some data regarding fight against corruption. Good afternoon to everyone, and welcome to the 7th edition of the Forum Justice Reform and Fighting Corruption. I will start with the Corruption Perception Index over the past 4 years. Although we have a decreasing trend, in 2024 we see that the Transparency International scored Moldova with the same rank, 76. So, although this average is lower than the EU average, countries with similar index was China, Bulgaria, and Romania that scored 46. A score lower than 50 shows that the efforts to fight corruption shall be intensified to reach the standards of Denmark that for the 4th year in a row is on top. Based on the public opinion barometer in September 2025, we can see that the corruption combating is one of the most important issues that shall be solved according to the citizens' opinion. It's even more important than many other problems, like to increase the living standards. This concern among citizens fluctuated across the years. So we can see that in 2024, this concern decreased by 10%, although it persists and it's in the top 5, the most important concerns among citizens. Here you can see the number of criminal cases that was managed by APO, Anticorruption Prosecutor's Office. You can see the number that were managed and the number of cases that were sent to court. You can see that the trend is increasing. At the same time, we saw the decrease of the number of high public officials that were prosecuted and their cases sent to court. The majority of these subjects were magistrates and members of the parliament. At the beginning of this year, a topic that was highly discussed was the PACO draft law. That means that will liquidate APO and PCCOX, two specialized prosecutors' offices. And the aim is to increase the efforts to combat corruption, hybrid threats, and organized crime. The first draft was approved in the first hearing. Also, we received a report from the Venice report concerning this draft law. So the Commission identified many risks towards the current ongoing investigations, also a gap of financial analysis and cost-benefit analysis. Also, this draft law poses risks for the security of the mandate and the independence of specialized prosecutors. I will stop here. Thank you so much for your attention, and I will give the floor to my colleague. Thank you so much, Victoria. Beyond the figures that are presented by the experts, I also want you to invite to watch a Vox Populi video to see the perceptions of people concerning this topic.
Da, sunt, cred că, anumite schimbări foarte puțin sesizabile.
Se creează o oarecare impresie că oamenii s-au schimbat, dar însăși mecanismele și sistemul nu prea.
Parcă se schimbă, dar mai mult nu. Eu cu soțul ne aflăm chiar într-un proces și aștept rezultat. Să vedem, ia că acum, că după ce o să avem judecată, o să vedem ce rezultat o să fie și cât adică justiția e de corectă.
Din păcate nu le prea simt, pentru că subiectul de corupție practic a pătrus în toate activitățile sociale din țara noastră, este și în educație, și în medicină, și în justiție, și în domeniul electoral și cam a acoperit toate sectoarele.
Nouă ne trebuie foarte mult timp ca să nu fie corupție în țară. Noi încă suntem deprinși să nu avem salariu, dar să întindem mâna.
Думаю, достаточно. Так, мне так кажется.
Eu, în general, consider că toate legile trebuie să fie cu mult mai dure. Toate, nu numai în domeniul corupție, anticorupție, respectiv, da. Dar orice lege trebuie să fie atât de dură încât omul să știe ce îl așteaptă când comite ceva.
Într-o bună din parte din cazuri, da.
Nu se face nimic, cred eu. Adică eu nu văd schimbările, fiindcă am fost și eu undeva, unde știu că legea lucrează, aici puțin lucrează. Doar stărui să lucreze.
Bine, când vorbim de instituțiile anticorupție, mă gândesc în mai multe structuri și instituții subordonate activității sau Ministerului Justiției, Centrul Național Anticorupție, Centrul Național de Integritate și multe altele. Acum să le iau pe un ansamblu de la parțial în jos.
Довольно, потому что в Молдове все спокойно.
E destul de slăbuț. Da, în ultimul timp se mai mișcă, dar foarte greu. Foarte greu.
Nu aș putea spune că da sau nu, pentru că nu le urmăresc chiar într-atât de mult, dar oarecare articole văd și cumva văd oarecare rezultate.
Nu cred, pentru că riscăm să creăm un centru unic de corupție. Ca cetățean care îmi pasă de comunitatea în care locuiesc, aș vedea asta nu ca un lucru pozitiv.
De la caz, uneori poate fi mai multe instituții. Și e foarte bine, concurează între dânsele.
Nu prea cred, pentru că nivelul de concentrație pe anume un domeniu, spre o crimă organizată sau o spălare de bani, adică ele cumva ar trebui să fie mai concentrate per nișă, să spunem, în limbajul economic. Deci, cred că ar trebui să fie pe domenii.
Organizațiile non-guvernamentale pot contribui pentru ca odată ce au făcut cunoștință cu o anumită problemă să o pună în evidență în fața publicului. Eventual, poate ar putea facilita un pic dialogul între persoanele care au avut de suferit și instituțiile statului.
Anume, ce vorbim de jurnaliști, e destul de important, pentru că oamenii trebuie să cunoască realitatea. Ce legat de ONG-uri, sunt destul de sceptic, sincer.
În domeniul ăsta, adică ziariștii de investigații, avem ziariști buni. În domeniul respectiv, deci, și practic total neprotejați.
Nu cred că cineva ar avea 100% asigurare.
Nu sunt protejați.
Iar acum îi voi invita.
And now I kindly invite the panelists to take their seats here in front. Serghei Karapunarli, the Deputy Head of National Anticorruption Center. Mr. Roman Porubin, Prosecutor, Anticorruption Prosecutor's Office. Oleg Afanasi, Chief Prosecutor within the Chișinău Prosecutor's Office. Igor Chiriac, Member of the Parliament, the Deputy Chair of the Committee on Justice, Appointments and Designations. Madam Livia Mitrofan, the Member of the Superior Council of Magistrates. Mr. Octavian Yakimovsky, the Senior Legal Advisor, Legal Resource Center in Moldova, and former Interim Deputy Head of Anticorruption Prosecutor's Office. Mr. Yakimovsky, I congratulate you with your new job. You will tell us where is harder, in state institutions or to work for civil society organizations. And now I want to challenge you. I know that organizers told you to deliver speeches in maximum 7 minutes, but let's have an interactive discussion. Therefore, I kindly ask you to make your presentations brief, shorten them, like deliver the presentation for 3-4 minutes, Because when it comes to the results, we have discussed about it, discussed this during various events. I would mostly want to hear from you the challenges that you have encountered in your activity. What would you need? What kind of support you need to do your work better? And I will start with Mr. Karapunarlu. The National Anti-Corruption Center in the past 2 years received new different tasks and also you got separated from the Anti-Corruption Prosecutor's Office. I know that specialists in the Anti-Corruption Prosecutor's Office were not glad about this change. Could you refer to these legal amendments and how these legal amendments helped you become more efficient as an institution to fight corruption, or maybe it infringed, challenged your work? Thank you for this opportunity, for the chance to communicate at this event with the law enforcement body representatives and representatives of civil society organizations. Thank you so much to organizers for inviting me. On behalf of the director of the National Anti-Corruption Center, together with the head of the Anti-Corruption Prosecutor's Office, is attending an international event on anti-corruption, representing Moldova there. Therefore, he was not able to come here, but I will represent the institution today. Thank you so much, organizers. Madam Mariana, thank you for your question. And when it comes to what I have heard during this Vox Populi video, indeed, these are the criteria that allow us to assess the current state of play. The perception of an ordinary person is a key criterion to guide us to strengthen our competences, to be able to detect, investigate a crime, and to send a case to court. Cases on systemic corruption, high corruption. The corruption phenomenon shall be treated as a negative consequence or issue. And we should have the same approach as doctors. We should prevent, we should be able to diagnose comprehensively the situation and afterwards to join our efforts to reduce the corruption risks. Therefore, as an institution, as a key institution in this field, we are guided by two important documents. This is the National Program on Integrity and Anti-Corruption. And the second is the strategy 2024-2028. These documents establish general and specific objectives to be achieved. While doing our work, we are very sensitive and attentive towards all other messages or risks to take into account. Besides this, we are also doing the proofing of various draft laws. It helps us to strengthen the ecosystem to fight corruption. We also, last year, we had 6 raising awareness campaigns to prevent corruption risks, to increase the awareness among public. So we are using these strategic planning documents in our work. Can we get back to the legal amendments to the law on National Anti-Corruption Center? You received new tasks. You started to work with territorial prosecutors' offices. Can you assess your activity after these legal amendments entered into force? We made our best to make sure that these legal amendments do not disturb the investigations that we are conducting. When it was decided that we have to cooperate with specialist prosecutors in territorial offices, we made this transition smooth. At the moment, we have a couple of cases still managed by prosecutors at the Anti-Corruption Prosecutor's Office, and the others are sent to the Territorial Prosecutor's offices. This is done to avoid the delay in investigations. So we found this temporary solution to be able to be efficient, to investigate the crime and to send the case to court. If to refer to certain figures, this year, out of 2,500 criminal cases that we had, more than 500 were initiated this year, other 2,000 were from previous years. So we doubled the number of cases sent to court. This is a good figure that shows that we've managed to overcome that temporary bottleneck. When it comes to the legislation, well, I want to thank the Parliament for being receptive, for responding right away to our requests, for giving us new tasks, including the mandate to investigate electoral corruption. We've managed to do all needed legal amendments to make our institution more efficient in investigating detecting and investigating crimes, including electoral corruption. I also want to thank our development partners for the support provided to increase our institutional capacities. We received many investigation tools, equipment that ease our investigation. Thank you so much. This is the reason why I asked you to be brief. First of all, to have a longer Q&A session, but also to have the chance to give the floor to others. And now I want to give the floor to Mr. Afanasi. We've mentioned that in 2023, legal amendments entered into force, and your prosecutor's office ended up to build joint teams, investigation teams with investigation officers from NAC, from National Anti-Corruption Center. So how this change affected the prosecutors from territorial prosecutors' offices, including your prosecutor's office in Chișinău? What did you feel and how it felt? Good afternoon. Thank you so much for the invitation. Yes, I'm ready to answer to this question, but just to make a disclaimer, I will present the opinion of my prosecutor's office. Indeed, in 2023, the legal amendments entered into force, and territorial prosecutor's office in Belt, Chișinău, and Cahul ended up to have a bigger workload, a higher number of cases. Once we had a higher number of cases, we realized that the number of issues increased as well, and also the number of delays could be increased. For us, it was important to take enough time to prepare carefully all indictments. What we did first, we assessed the amended legal framework. We tried to adjust the tasks internally, the work internally. In our Chișinău prosecutor's office, we restructured a little bit the things. In 2020, actually, we were part of a new restructuring reform within our office. We adjusted our structure according to the judicial map in Chișinău. Since 5th of August 2020, Chișinău Prosecutor's Office has 7 offices, 7 territorial offices that are spread across Chișinău sectors. So one office is responsible for representing cases in court. One office is responsible for criminal investigation. Led by prosecutors. Also, we have a separate section. So previously, that was the police section and border police section, Chișinău Airport. So that section represented the criminal investigation officers of police, border police, and the Chișinău Airport. Just to make it clear, so the offices of Chișinău Prosecutor's Office are distributed according to the sectors, the districts of Chișinău. Each of these offices has a head prosecutor, and they work closely with police inspectorates from that particular sector. When the legal amendments entered into force, we applied it immediately. We didn't have much time. We realized that from right away, from the 1st January 2024, we will have to cover the cases that will be initiated by NAC in 2024. Okay, I won't give you too many details in this regard. It was clear that we won't receive all the cases that were managed by Anticorruption Prosecutor's Office. We had 8 prosecutors in that section that was responsible for criminal investigation, and we had around 300 cases. You had 300 cases up to that time. Yes, there was a stock of 300 criminal cases. So cases that were initiated by police inspectorate, by us, including road traffic crimes, are investigated by a separate section. But our office is leading the investigation of those criminal activity, of those criminal investigations. We did not increase the number of prosecutors because we were thinking that this is a temporary measure, and those prosecutors between 1st of January until 1st of April, we had 8 prosecutors. We cooperated with Anti-Corruption Prosecutor's Office to have this smooth transition, because on the one hand, the APO had a huge number of cases that had to be solved, and on the other side, you should understand that the cooperation between prosecutor's office and criminal investigation offices is not reduced only to the investigation itself. We have many other tasks to do jointly, like to register, to record certain events, to conduct special investigation measures. The criminal investigation itself is just the top of the iceberg that is seen by everyone. But until then, there are many other stages that we need to work together. So we tried our best to arrange the things and to cooperate better. And since April 2024, when we received the entire stock of cases, they were amounting to 400 cases. Also, we designated 4 additional prosecutors from other offices. We even designated a prosecutor that was responsible to represent the prosecution in court. So we designated that prosecutor to this specific section. We trained them because, well, we are qualified to work as prosecutors, but we do not have or didn't have specialized training on anti-corruption. And since we are supposed to investigate these particular cases, we needed more insightful training on anti-corruption. So now this section consists of 15, more or less, 15 prosecutors. Well, we have staff turnover, of course, but in case someone resigns, we try to designate someone else to keep these 15 working prosecutors in the section that is responsible for investigating anti-corruption cases. In 2024, we finalized 306 indictments, and this year, up to now, we finalized 345 indictments, or criminal cases to be sent to court. I wouldn't say that we have huge problems. Yes, we do have problems. The fact that we do not mention them, it doesn't mean that we do not have problems. But probably it's the case to mention them. Well, we are trying our best to organize the work properly. Now, you have this section of 15 prosecutors, and you lead the criminal investigation on corruption cases that were initiated by the police and by the National Anticorruption Center, correct? Yes. As for now, we have around 400 cases initiated by NAC and around 300 initiated by Border Police, Chișinău Police Office. But these 300 are road traffic crimes or general crimes committed in municipality. But in the latest years, the influx of passengers at the Chișinău airport increased significantly. There is a police office there established, and also the number of cases due to that increased. We encountered many difficulties, but we tried to cooperate better with police, with the National Anti-Corruption Center. We all know that a case can be positively solved when efficient special investigation measures are conducted. And we are doing this, we are good at it. And we also know that if the case is investigated badly, then we won't achieve any results. Mr. Afanasi, I will interrupt you. I will get back afterwards. I have a couple of questions. I'm pretty much sure that there are many other questions in the room, but let's move next to Roman Porubin, prosecutor within Anti-Corruption Prosecutor's Office. So far, we've heard the position of National Anti-Corruption Center that started to work with territorial prosecutors' offices. Mr. Karapunarli highlighted this positive evolution of things. So, when APO stopped working together with NAC on anti-corruption cases, we saw a huge backlash and negative feedback. Also, the tasks for APO have changed. You continued to be responsible for high-level corruption, but somehow the society had bigger expectations and you didn't meet them. So what were the challenges? Thank you, Madam Ratsa, for this introduction. Good afternoon to everyone. Thank you so much for the invitation. We are interested in this topic because it affects us directly. It's indeed important to have such event, and it's good that we organize this forum regularly to openly discuss the situation in this field. It's good to zoom out and to understand what has happened so far when it comes to fighting corruption. Madam Ratsa made an intro. We also had that video, the perception of citizens concerning combating corruption. We somehow expect to receive these critics. We expecting them. When it comes to the prevention of corruption, we have a very strong legal framework. We have the law on assets declaration, gifts declaration, wealth declaration, income declaration, and so on. When certain disruptions are experienced, prosecutor's office, anti-corruption prosecutor's office should be engaged to eliminate these risks. We all know that it's almost impossible to eradicate corruption at all. There are no countries that manage to do so, but we still need to continue to make efforts in this regard. I have a short presentation for you. So despite all these legal amendments that entered into force, we, as prosecutors, continued to follow the procedures and do our work properly. When it comes to notifications in 2025, compared to 2024, we registered 141 criminal processes compared to 122 in 2024. We started criminal investigations in 90 cases in 2025. In 2024, we initiated 79 criminal investigations. Also, 48 criminal processes did not provide enough evidence to start the criminal investigation in 2025. That was the same. In 2024, we had 38 cases as such. Here you can see the criminal investigation statistics for 2024 and 2025 by 1st of November. you can see that this year we had 204 pending criminal investigations compared to 217 in 2024. By November this year, we sent 32 criminal cases to court. In 2024, we had 55 cases sent to court, plus 16 that were led by the National Anticorruption Center. Also, 30 cases were cancelled. When it comes to the trials, so we received 178 sentences against 301 subjects. In 2024, we had 183 sentences against 251 people. In 2025, you see that 112 detention sentences were issued compared to 91 in 2024. 22 cases were acquitted compared to 21 cases that were acquitted in 2024. And here you can see the difference in the percentage. When it comes to safety measures taken this year and last year, prosecutors within APO seized assets amounting 59 million lei. That's much less compared to what we've managed to recover. But we've managed to do so. So the recovered assets this year amounted 342 million lei, which is quite positive. I do believe that there is always space for more, but we are in a constant change. And despite this situation, APO works on cases constantly to avoid any delays. Some challenges that we have encountered are the following ones. During pre-accession period, many funds shall be provided to Moldova. Moldova will access many funds, and that's a crucial debate to be done because European funds shall be secured. The Anti-Corruption Prosecutor's Office and other law enforcement bodies shall prevent and combat the crimes that will embezzle the European funds. I do understand that the EU funds are easy money, right? But we should prevent any crimes in this regard. Since 2024, we received millions of euros as grants. You also know that the EU directive was transposed, the directive on financial interest. The law that transposes the directive was adopted in summer this year. We have a legal framework in place that allows us to investigate embezzlement or any other crimes related to funds. But could you tell us what kind of ongoing cases do you have on embezzlement? This is what I wanted to tell you. In 2025, in August, the government adopted anti-fraud governmental system. And the anti-fraud authority at the national level was designated the National Control Authority. So it's an institution that will so also in August we signed a memorandum of cooperation with this institution to have a constant cooperation with them and also to cooperate closely with the European Anti-Fraud Office. I cannot give you a clear figure, but many notices were submitted by this body. I'm pretty much sure that in the nearest future we will be able to provide disaggregated data concerning these particular crimes. Since we are in constant change, we are also trying to adjust. The fact that we are a candidate state, it means that we are cooperating closer with other law enforcement bodies. We are taking into account the provisions of the accession agenda, the growth plan. We are familiar with those indicators that shall be achieved. We we report on monthly basis on those indicators. And by the way, do not forget the civil society to cooperate with them as well. Mr. Porubin, I also have another question to you. You did not refer to it. It's strange what's happening in the last half of year. The development partners and the civil society talks much more about the needs of the law enforcement bodies, much more than the institutions themselves talk about it. The Venice Commission stated that the law enforcement bodies, anti-corruption institutions shall increase their capacities. Unfortunately, there were many promises to strengthen the capacities of APO, but they ended up to be just promises. Now, why do development partners talk about it, but the institution does not talk about this need to constantly increase your capacities? We are trying our best to communicate efficiently, but of course there is much to do in this regard. Maybe our messages are not always perceived correctly by the society. At the beginning, you've mentioned that APO is very upset by these legal amendments. Well, this is what the head of the institution told at that moment. Well, this is maybe a perception. We do not refuse it. But our task is to have this institutional cooperation and to do our tasks according to our mandate. It's obvious that after the law was adopted, according to which the tasks between NAC and APO were separated and it was clear what to do. At the beginning, we were basically alone. We didn't have a special section or department to do special investigation measures. We didn't have the needed equipment to do this. But in time, we've managed to purchase, to endow it. We built up a structural unit to do all these measures. We have the needed equipment. Of course, there is space for more because capacity building always brings benefits. And now we are capable to do these special investigation measures. Thank you.
Thank you. Let's continue with those that are developing the anti-corruption law. Mr. Igor Chiriac, you are the author of almost all amendments and changes that we discussed about today, and you are the author of the decoupled anti-corruption national anti-corruption Center from the Anti-Corruption Prosecution Office, and also the author of the PACO amendment. So we have heard the experiences. We are not addressing this for the first time, but we had today these discussions as well, and I appreciate the sincerity of Mr. Afanasi, who presented the challenges that they have had from the very beginning. They thought that was a temporary measure, the institution was overloaded. So please tell us, how did you reach the idea of making these changes? Why did you think that the results would be good? Because as far as I understood, they were not consulted before making the changes. You had some discussions only after the changes were made. Fighting corruption is a priority for our entire society. And I would like for us to make some steps backwards, not only when these changes were made. The society felt the need for a change, and these changes were looked for because of maybe some modest results or some expectations that the society had to see outcomes of high-impact cases. And the need for these changes derived from this feeling that people had. When speaking about changing the competence, I would like to say that we have discussed these changes before they were made. And if we are to analyze the whole context, the whole picture, we can see, and we saw back then when discussing the vetting of judges and prosecutors, we saw a message delivered by the management of Specialized Prosecution Office, as well as by the other prosecutorial authorities. So when the vetting itself will start, when prosecutors will receive notifications, many of them will resign. In addition to that, there is a need to have some prosecutors in place who will be available to fill in the vacant positions. And during those discussions and based on the recommendations that we received, we decided to establish two institutions in charge of fighting corruption. The Anticorruption Prosecution Office to deal with large-scale corruption, some special persons such as prosecutors, ministers, managers of central institutions, members of parliament. Yes, I've said members of parliament. Yes, ministers, members of parliament, even the country's president, and the National Anti-Corruption Center to deal with systemic corruption. That is also very dangerous for our society. And we have seen that these changes had some positive effects. We've seen a positive dynamic with regards to the cases that were sent to the court. We've also seen a positive dynamics in public communication of the Criminal Investigation Authority. And also, we've seen that when this competence changed, they announced about starting new cases, new searches. And today, if we analyze the public communication of the Municipal Prosecution Office and the National Anti-Corruption Center, we can see that the number of cases that were sent to court under the management of municipal prosecution offices. So I have to highlight that it is not only the prosecution office of Chișinău municipality. doing that. The criminal investigation is done also by the prosecution offices from Belz municipality and Cahul municipality. And I believe that this change allowed, first of all, to streamline the criminal investigation on cases of systemic corruption. Second, we allowed the anti-corruption prosecution to focus only on the high-level, large-scale corruption and special subjects. And at the same time, I believe, that's my personal opinion, we prepared a number of prosecutors in municipal prosecution offices who in the future will be able to fill in the positions of anti-corruption prosecutors. So I believe that there are no ideal decisions, but the best thing is to do something rather than not do anything. And I believe that this change of competencies produced more positive results rather than negative results. But you've spoken about the successes registered by the National Anti-Corruption Center together with the territorial offices, not only the Chișinău municipality. Do you have the same feeling of being proud of the efficiency of anti-corruption prosecution office? Well, of course, if we talk to people and if we ask them, because this is the biggest and the most important measure. It's subjective, but it's important. Well, I believe it's the most important. So if we ask people what is their opinion about fight against corruption, they will say that it is not enough and there is room for improvement. So I think that should be our goal. And the last question regarding legal amendments. Of course, we always start from the principle of good faith in anything we do, in the activity of everyone. And I've seen this good faith reflected in the law that underpinned the decoupling of the two institutions. So this good faith is reflected in the final and transitory provisions, which stipulates that within 3 months the Parliament shall make sure that the government will provide a building to the anti-corruption prosecution and the needed resources. Because after decoupling, it was clear that the tools remained with the National Anti-Corruption Center, and now we have a doctor without any tools to operate with. So this was not done, and we have almost 2 years, and these resources have not been provided yet. Well, I believe there is always room for improvement, and some steps have been done in this direction, including specialized equipment provided to the Anti-Corruption Prosecution Office. I believe that we can improve things, as I've said already, but on the positive side, the assessment of prosecutor from the Anti-Corruption Prosecution Office is on its way, and I believe that at the beginning of next year we will see it completed. And in parallel, we have to make sure that we have a strong institution able to cope with challenges, because all of our work is done for the benefit of the society, as well as for our EU accession commitment. Unless we have strong institutions, our path, our road towards the large EU family will be obstructed. Yes, thank you very much. So we have discussed so far about the management of criminal cases on high level and systemic corruption. We have the second link, securing justice in this regard. These are the courts. And recently we had a lot of discussions in the context of vetting that affected courts. So what should we do to make sure that corruption cases are not affected? There were two solutions. One tabled to the parliament, the one to establish an anti-corruption court, and another solution which came as a quick fix, but it was welcomed by professionals, by the civil society, experts, this specialized panel of judges. Mrs. Livia Mitrofan, please talk about them, and please focus on what will happen after the law is amended. So now we will have anti-corruption panels in the first instance court and court of appeals. This will be done very soon, so please tell us more. Good day for everyone. Thank you for this opportunity to speak on this very important topic for our society. From the very beginning, I would like to say that I have been participating in these forums organized by the Legal Resources Center since 2019. Only in 2025 I've become a speaker. You were present at all of them, I can confirm it. And you made speeches in all of them. Yes, indeed, I did that. Okay, so if we are to compare our state, I would always compare it with a Swiss watch. And each piece is important to make sure that the watch shows the correct time. And if one piece goes out of order, the watch will stop. And if someone commits corruption, he or she should be eliminated from the system, because that person would be a barrier in achieving our future. So that's my opinion about corrupt people. It's neither ours nor yours. A corrupt person is the person who is stealing our future, who is stealing our chances for a better future. So I believe that all of us have to be aware of this. And when we overcome our values, you become automatically part of that system. Yes, I was the president, an interim president of Chișinău Court, which, on the basis of the Superior Council of Magistracy decision to establish a specialized panel, so I appointed 9 judges to be specialized in this area, and they were supposed to investigate high-level corruption cases that were supposed to be submitted to the court by the Anticorruption Prosecution Office. As a result, a lot of criticism was generated, but in the end, I would like to show you some results, some figures, because in our society we always like to criticize and express our opinions, but what it matters is the final result. So I would like to tell you that we have set up those specialized panels. Initially we had 9 specialized judges, now we have only 4 specialized judges investigating, examining those cases. 260 criminal cases on large corruption have been examined, and in 174 cases, sentences have been already pronounced. One case contains a number of defendants, and I'm glad that the prosecutor from the Anti-Corruption Prosecution presented the how they prepare the indictment, and this is a proof that the specialized panels do work. So we can see that we have 12% payment rate, which means that the judiciary is performing its role. Out of these 260 cases that were examined, took place, so that you understand the complexity of these files. So we have more than 7,600 court hearings, the duration of case examination was decreased by 30%. Though both our society and the Romanian society was shocked by a recorded investigation, I've watched it, I saw what judges would say, and everybody tried to make some parallels, but everybody forgot about the purpose. Back there, they said that the panels were changed in order to delay the cases, whereas the specialized panels created in Chișinău were established for a different purpose, in order not to delay the examination of criminal cases, so that the judges pronounce their judgments without risking to exceed the limitation period. Because back then I analyzed the situation to understand what is the reason for delaying the examination. I've also analyzed all of the researches done in this regard. So I've seen two factors: the volume of work. These cases are very complex and lawyers are very active, as they should be, and these do not result in tergiversations but in delays. But as a result of those delays, the limitation period expires and the society does not see any outcome on the corruption cases. So these specialized panels were established in order to be able to provide the expected response, so that the society changes its perceived opinion. So I've said, now we have 4 specialized judges. 19 cases are pending now. None of the case from 2024 is at the preliminary stage. But they have progressed quite quickly, and this is a good sign. Also, I would like to say that the establishment of specialized panels helped us persuade the parliament and government to give up on the idea of establishing specialized courts. The specialized judges and the Superior Council of Magistracy invested a lot of efforts to persuade that a specialized panel of judges is enough and is an efficient tool that can be used to examine corruption cases, high-level corruption cases. The Parliament has accepted our position. The last version of the law stipulates specialized panels of judges, not a specialized court, and we're very glad about this. Also, the law on judiciary organization was amended, where the number of 503 judges per system was supplemented with other 26 judges. So we believe that it helped strengthen the whole system. I would like to address the Supreme Court of Justice before moving to the mechanism adopted by the Parliament. So I've studied the case law of the Supreme Court of Justice on giving and taking bribes, because the Supreme Court of Justice can issue judges that unify the practice of lower courts. They somehow set the tone from the top. In 2025, the Supreme Court of Justice reviewed 82 corruption cases and 62 are still pending. They said that by the end of the year, they will have only 50 cases remaining pending. But it's important to say that no corruption cases in the Supreme Court of Justice was sent back for retrial. The Supreme Court of Justice prioritized its work so that it focuses on corruption cases. It organized a number of public court hearings. We can watch them on YouTube. And after that, they have pronounced final decisions, and those decisions will help lower courts to issue their judgments. Regarding courts of appeals, as a result of the vetting procedure, which resulted in the dismissal and resignation of a number of judges, was in stagnation in 2024. In 2025, we've seen higher speed of examining corruption cases, and at the end of 2025, we've seen a number of sentences pronounced both on old and new corruption cases, and we hope that in the future Courts of Appeal will see this as a priority. And we're still waiting for this new. Yes, regarding the specialized panel of judges. In June 2025, the law on specialized panels was approved. It entered into force in September 2025. During this period, the Superior Council of Magistracy focused on the development of the secondary legislation. We developed a regulation on how to organize the competition. This regulation was published, and after that, we had to change the staffing lists of the Chișinău District Court and Courts of Appeal in order to have court clerks, specialized staff in the Chancellery. We prepared these amendments. The State Chancellery issued its positive endorsement. So we have announced the competition, which ended on December the 12th. The sad part is that we do not have any applicant yet. And if you ask me why, I have a clear answer. In the past year, so there are a lot of discussions recently about some people that are already decided beforehand to work there. And this is a dissuasive factor. This discourages potential applicants. Number two, the law was approved, but the judges that will review these cases were not given any salary guarantees or social guarantees in addition to what they had. But the practice has shown that the judges, including myself as the president of court, were denigrated, threatened, blackmailed when we examine such cases. So in order to motivate judges to apply, the state should provide enough salary or social guarantees so that they apply. Because judges would like to choose a more comfortable area of work rather than being always discussed in the media on some anonymous social media. So I believe that we will have applicants when they have an efficient salary motivation, because as fighting corruption, as you have seen in 260 cases, there have been about 7,600 court sessions. So these are very complex cases. So it's very complicated to always be in the eye, but not in the eye, under the magnifying glass of the society. So they analyze everything, what you are doing, how you work, what your family members are doing, and so on and so forth. And we have another challenge. It is our office. That law, according to that law, the government was supposed to identify premises for the specialized panel. It was not identified yet. The Agency for Court Management informed the Chișinău District Court about this, but we're not complaining about the lack of building, because, as I've said, we have this as a national habit to complain. No, we will continue discussing with the government in order to identify the right premises, and I'm sure that building for the office of Chișinău District Court will be found. But now we have to work depending on the circumstances and resources that we have. In the end, I would like to tell you the following. When you are a decision maker in a system, irrespective of its type, I believe that it is not appropriate to give recommendations to other systems. No, we have to focus on our own work. Fighting corruption is a common activity, is a joint activity. So I would like for the state to strengthen this mechanism, both at the prevention, investigation, response, and case investigation levels. And I would like for institutions to focus on results more, rather than on gossips, talking, and because this affects the integrity. I liked Mr. Afanasi's speech, how they organized, how they found solution, and also because we need to find solutions. We should not criticize each other. We should not complain. Complaining is not a solution. Thank you very much. If you have any questions, I am ready to answer them. Yes, I have in this context a question. By the way, premises, I believe this is a huge challenge for the judiciary in Moldova. But you mentioned a competition with no applicants. Do you have a deadline established by the law until when you have to establish these specialized panels, both in the first instance courts and in the courts of appeal? And what will you do if nobody applies? We have a deadline in the law, and we also have a deadline in the integration plan, which is December 2026. So this is a priority for the whole country. So I believe that we need to have a sincere and frank discussion with judges in order to encourage them to apply. So it was already noticed that there are no pre-arranged lists. Number two, we have to talk with the parliament to decide how to provide guarantees, securities to people that will apply for these positions. And three, we need to have more intense discussions with the government on identifying premises, right premises, because as a result of GIZ project, they provided the necessary equipment for anti-corruption courts, and recently the Superior Council of Magistracy had a handover event. So computers, printers, video conference systems were handed over to courts. So when we announce competitions, we need to have a more open communication with judges. So I believe that we omitted this part because we focused more on approving the vetting reports, on developing the internal framework and other priorities. But we have learned the lesson, and in 2026 we will focus on this. Thank you very much. I am sure that there will be questions from the room, from participants. And the last speaker from this panel, Octavian Yakimovsky. I do not know how to introduce you. Of course, you are presented here as a civil society expert. You have criticized a number of processes, but my question is a bit different. The society's expectations in terms of anti-corruption is clear, in particular if we speak about high-level corruption. We cannot say that the authorities have neglected this expectation. A number of legal amendments were made, reforms were implemented. We've seen the feedback by the population, who is still not fully satisfied with the efficiency of anti-corruption efforts in Moldova. So the problem is known, efforts were made in order to enhance the capacity of the state to fight high-level corruption, but people are still not totally satisfied. So where do we have this disconnection? Why do we have this effort made and a result that does not meet people's expectations?
You say that you cannot say that the law enforcement bodies neglected it, but they neglected in terms of high-level corruption. And if I were to use some comparison, then let me give you a couple of examples. The draft law probably was written on 31st of July and voted urgently. It wasn't consulted publicly. And In that law, it was stated that our mandate will be narrowed according to the law, but we had to cooperate with NAC on temporary basis. When APO was decoupled from NAC, APO was able to continue to deliver. The same problem with the facility, with the building. It's not a problem to identify a building for us in Chișinău. It's not a problem. The budgets. We shouted out and we said we need these budgets to support efficiently APO. But in 2024 and 2025, we had the same budget as in 2023. Nothing has changed. We saw the budget draft law, and although it is stated in our law that specialized prosecutors' offices should have a separate budget, we still do not have a separate budget. And when it comes to the equipment, the state did not provide us with this equipment to do special investigation measures. No, we received it as a support from the development partners. We did not receive the equipment or any other tools from the public budget. APO was not supported during this period. The development partners supported us. Even now, we have 50 vacancies. We have investigation officers in a number that is 3 times lower than it should be, the number that we should have. And more than that, Prosecutor General didn't want to send to APO certain high-level corruption cases, like around 30 or 40 cases that had to be transferred to APO, as it was stated in the law that was adopted by the parliament. That cases were sent to NAC, a center that is not supposed to tackle high-level corruption, but small and systemic corruption. Now, let's get back to that initial draft law that was publicly consulted. So APO needed to have necessary support from NAC. The criminal investigation officers had to be done by APO. Police, together with territorial offices, had to work with NAC to combat small corruption. But the police was against it. Yes, they were against because they were afraid of the high number of cases that they would receive. But there were around 100 cases that had to be transferred from APO to police, meaning that each prosecutor at the police would receive 1-2 cases more. When I used to work for APO, I was surprised, and I'm still surprised now, that we do have the report of the European Commission, we have the report submitted by the Venice Commission, we have Greco recommendations that state we should increase the capacities of APO, but no one does it. APO submits on the EU database the statistic concerning the high-level cases, and the only thing that I see that is functioning right now, these are these specialized panels that deliver good results. They decrease the period of time for reviewing the case, but on the other hand, we see that APO has less and less cases sent to court, and reduced number of them are cases of high-level corruption. Last year, the vetting process started. Besides this, the Parliament wanted to liquidate these two specialized prosecutors' offices and initiated this PACO draft law. Plus, we had an additional control missions at our specialized prosecutors' offices. So it was a very tough year. I didn't want to see such an attitude towards us. Since we have an institution that does not have its capacities strengthened, we would not be able to deliver any results to the society. Since Madam Mitrofan has a meeting to attend and shall leave earlier, I want to ask you whether you have any questions for her. Please raise your hand and introduce yourself if you have any questions to Madam Mitrofan. Are there anyone who wants to address some questions? No one? Okay. No one is there to address questions. Journalists, this mean journalist, will watch out how SCM will establish these anti-corruption panels, and we will see how they are functioning. Good. Let's continue our discussion. Let's get to the Mr. Igor Kyriak. Do you want to comment on what Mr. Yakimovsky has said? Because everything that he has mentioned is contradictory to what you have said. The state does not provide any needed support to these specialized prosecutors' offices. What can you say? When a certain solution is discussed, there are many opinions. So we've heard a different opinion that certain things should be done differently, but if to leave the emotions aside, my question is the following one. When APO led the criminal investigation together with NAC, what kind of results did you achieve? Well, you did not deliver those results that the society expected. The biggest problem is not the decoupling or coupling certain institutions. The biggest issue that we have is the willingness, determination, and courage. This is what we didn't have so far. And I notice that we can see it now. We have sentences issued, high-level officials condemned. We all expect that important cases are solved and the society trusts law enforcement bodies, prosecutors' offices, courts, justice institutions. This is the most important.
So I will ask some questions. Do you want to say something, Mrs. Yakimovsky? And other panel participants can step in as well. So let me explain how statistics work. In EU, esteemed member parliament, statistics work differently. So fighting low-level corruption is not that important if you want to join EU. So please analyze the Anti-Corruption Prosecution Office reports, and when the two bodies used to work together, they investigated the highest level cases. I don't know what you're doing now. I want to tell you that the sentences pronounced now are the result of efforts started in 2010 2020-2021, and when the Anti-Corruption Prosecution Office was criticized for not coping with electoral crimes, which now is praised for its outcomes. And actually, as I've said, these are the outcomes of cases, the investigation of which started back then. Mr. Kyriak, would you like to reply? Well, I believe that we can discuss this topic forever, and we can organize some roundtable discussions on this very topic. Yes, I have to recognize that in an editorial article that I published about 1 week ago, I expressed my regret, saying that unfortunately our Anti-Corruption Prosecution Office are not working anymore. They're just wasting their time in the office, and they are not looking for the most corrupt people. And to understand their strength and courage, you have to see whether they are ready to investigate the governing officials, not only those in the opposition. So there is a question from the room. In their pre-vetting commission, it declared that the Anti-Corruption Prosecution Office did not provide any information that was requested about assessed subjects. How do you explain it? Yes, I have noticed the statement made by the Commission representative, and I contacted the person dealing with it. I sent a message to that person, and this 100% refusal is not correct. We provide information on all criminal cases, be it either criminal investigation or examination in the court. We deliver information as requested. For a single person, or as we did recently last week, we scanned more than 1,000 pages and we sent it to the Commission. The problem is when they have requests on matters related to cases that are still under criminal investigation. This is a very sensitive topic. On the one hand, we have Article 212 in the Criminal Procedure Code that obliges prosecutors to ensure confidentiality. On the other side, we have a special law that forces us to deliver this information. So now it's the decision of each case prosecutor to decide whether to comply with the confidentiality requirement stated in Article 212 because two sides are involved, defense and prosecution. But the secret of investigation is not absolute. There are some information that cannot be revealed, whereas other information can be revealed because you do not make them public. You send them to the Commission that also has some confidentiality obligations. Yes, that was my very point. We have only the confidentiality of criminal investigation, and there is no secret information within the criminal investigation. So it is up to the prosecutor to decide what to communicate and what not to. But I cannot give you more accurate data because I never processed such requests for information myself. But what I can tell you for sure, there was no 100% rejection of requests for information. Another question for you from the public. Are there any internal criminal investigations related to destroying evidence? I guess prosecutors destroying themselves the evidence. I am not aware of that, but what I can tell you now is that we have certain cases under investigation that are related to to making public some data. So a number of people participated in the investigation, so it's very difficult to have evidentiary material to prove this. Any leak leaks of information are very difficult to prove. But I do not have an answer regarding your question with destroying evidence. Are there any questions in the room? If yes, please raise your hand. If not, I have a question to Mr. Afanasi. So you've said how you started cooperating with the National Anti-Corruption Center after these two institutions were decoupled. You said that this change was made when you were not prepared. Initially, you thought that it was a short-term solution, and I don't know why you thought about it. It's not stated in the law. But my question is the following. It's about trainings. Of course, the prosecutors from Territorial Prosecution Office have developed other competencies and skills during their work compared with the competencies and skills developed by anti-corruption prosecutors who know how to prepare rogatory letters or other matters that people from territorial offices are not doing. So my question is, at what extent did you manage to develop these missing skills of those prosecutors, and who provided those trainings? Thank you. Regarding the first part of your question, I would like to say that in August I was on vacation, and when I returned back to work, I saw the law. And regarding trainings, this is a very important element for us. All of the cases are treated the same by us. A criminal investigation should be started if the right facts are in place, and prosecutors, yes, of course, they have the general qualifications and skills. All of them had it. Of course, their skills have been tested, but they were very brief. We did not appoint prosecutors with less than 5 years of working experience. After that, we provided trainings with the help of the General Prosecution Office, and as part of international projects, we appointed prosecutors to participate in those trainings. I myself participated in some trainings as well. We made an assessment, we identified the biggest challenges in this regard, but when we speak about corruption crimes, we see it as a crime involving people. For example, for other types of crimes, we do not know the person. We have to identify who is the person involved. Whereas in corruption cases, the person is known, and they are not that complicated. Complications might appear when there is a certain status of the person, because people with a certain status might be reluctant to cooperate, and then at the next level we have to present the case in the court. There the prosecutor is independent. We do not have a rigid hierarchy there. Yes, we do some monitoring via the General Prosecution Office that has a specialized unit in charge of controlling the judiciary part of the process. And But I believe that this problem will be solved soon, as the judge has recently said. So we do not travel to regions. So if the case prosecutor needs to be present in a court session in a certain region, then they do travel there, but most of the times they do not. And today we do not differentiate by type of crimes or by people involved. That was not my question. I did not mean that you have to differentiate or prioritize your work. That's your internal decision. I believe that you do have certain priorities. You do not treat all cases the same. But my question was about the skills and professional competencies of prosecutors. For about 1 year, anti-corruption prosecutors are telling that they do need trainings, they need skills upgrading. So in 2002, when I joined the prosecution office, we had the Center for Combating Economic Crimes, and I used to work in Lăpușna County, Hâncești town. So back then, everything seemed to be new to us, but all prosecutors have experience in investigating cases. So they are prepared. They know how to do the investigation. Whereas regarding some specific elements of our work, the General Prosecution Office has a regulation on the international legal aid, which is compulsory for us. So rogatory letter is first sent to the General Prosecution Office. They have a specialized unit that check it first and then translate it. And it is sent to that respective country, and then the reply is provided also to that specialized unit. We do not receive it directly. So that specialized unit at the General Prosecution Office has the goal to make sure that the practice is unified. And the last question.
The last question I want to discuss about PACO draft law, this experience. If to refer to the Venice Commission, we understand that this is not the best option. I don't want to discuss about the initiative itself because we have already highlighted many things, but what I want to discuss is what do we do next? How this kind of justice reform initiatives shall be established to make sure that we do not end up in a situation when the citizens are against these initiatives, when experts and specialists from the justice sector do not agree, when Venice Commission experts do not support positively these initiatives. But these reforms have a good impact on high-level cases. So how this communication should be conducted, I will start with Mr. Chiriac, and afterwards I will give the floor to the other panelists. Thank you for the question. If you allow me, I will get back to the Venice Commission report, point 21 and 58 in the report. The Venice Commission stated in the report that at that particular moment when the draft law was discussed in February 2025, that was justified, taking into account the risks that were experiencing the Republic of Moldova, or to which risk it was exposed. We assessed the risks. Those risks were recognized by the Venice Commission as well. The Venice Commission also stated that those risks and those reasons established, highlighted in February 2025, are not so severe right now. Take into account that in 2025 the Republic of Moldova had the elections, and I think everyone here in the room agreed to the fact that the intervention of the law enforcement bodies in 2025 was way different compared to the interventions in 2024. That PACO draft law was a kind of a measure to strengthen the democracy in the Republic of Moldova, or at least one measure that was proposed by the Parliament of the Republic of Moldova to protect the democracy. But in the end, you managed to achieve these results without PACO. Well, my opinion is that when you start discussing this subject, engaging many stakeholders, civil society, specialized prosecutors' offices, you give a reason for them to reflect, to assess, to make an analysis. It allowed us to assess the risks that we have experienced back in 2024 and to understand what else should be done. Yes, we do have an opinion, feedback regarding PACO draft law, but I wouldn't say that it's a negative opinion. Well, we do have the report of the Venice Commission that includes a couple of recommendations for Moldovan authorities to examine the solutions presented and to choose the best one. The Venice Commission highlighted three basic recommendations. The first one was you either leave these specialized prosecutors' offices the way they are, or you take into account the other proposals of the Ministry of Justice that were stated at the beginning of 2025. One of those proposals was to merge the institutions, and the prosecutors working for Pecha Cox and APO will continue to lead and investigate the cases that they had. Another recommendation was to take into account all the risks and to identify the measures to tackle them. It's good that we have this report of the Venice Commission. It's a starting point for us to assess what to do. The state authorities, the Ministry of Justice will have a discussion with prosecutors' offices, with specialized prosecutors' offices to identify the best solution. Now, the Venice Commission also has stated that the Republic of Moldova is the second country in the world that received the biggest number of opinions from the Venice Commission. The first one is Ukraine and the second is Moldova, which means that when we want to make certain changes in the justice sector, we should have a comprehensive discussion within the country and outside with external partners. It's good that we received these recommendations. We will take them into account. You have highlighted three recommendations. Which of them is the best one for us? Or which do you support the most, or you're open to support the most? Well, I don't want to give my personal opinion to avoid any speculations. That was a draft law that was drafted and signed by 3 members of the parliament from my fraction. I think it's good to wait for the feedback provided by the Minister of Justice after doing a comprehensive review of this draft law. But all the concerns that have been stated in the Venice Commission report will be taken into account, including all those risks that have been highlighted. Let's get back to my question about lessons learned. What do we do next to make sure that the laws that are adopted by the Parliament, because the Parliament is the one to decide what kind of laws we will have in the country, and everyone else shall execute and should agree with the provisions of those law, and also should be engaged in the consultations and policy making. Now, what do we do next? The PACO draft law was registered in the parliament without public consultations. It just, like that, just dropped out of the sky. Then in June 2023, we had also other legal amendments done. So let's learn from it. What do we do next? Well, we all need to learn from past experiences, to learn from critics, to make sure that we do not make these mistakes again. Let's recall the end of 2024. I do understand that it's a priority for us to have these public consultations, but in 2024, in 2025, when we had the presidential elections, we experienced high electoral corruption, widespread electoral corruption, and the society actually requested it from us. What do we do to tackle all these problems? We had a hearing at the parliament. All interested state institutions attended that meeting, and everyone actually had the chance to be engaged in all those debates. We also had many discussions within our parliamentary commissions. We came up with various recommendations. Also, the National Security Council also issued number of recommendations, and only afterwards the draft law was developed. It was needed at that time to change things because it was already February 2025. We were expecting a new electoral process, and we responded right away, taking into account those circumstances. But it's indeed so. Any draft law shall be publicly consulted as much as it's possible to explain the provisions and to listen to others' opinions. Okay, now let's go one by one. What are the steps taken by your institutions next? Before answering to your question, I want to comment a little bit. Within our prosecutorial sector, we do have a legal framework according to which certain documents shall be consulted, discussed, and so on. And also, as part of that framework, we are requested to come up with certain recommendations to improve the policy making. And we got engaged, but almost any time when we submitted certain recommendations, those recommendations have not been taken into account. Like the draft law that we consulted, discussed, come up with recommendations on, was not changed at all. When PACO draft law was promoted, and according to each pardon me, Mr. Kyriak, you probably remember that we have attended a couple of meetings on the within the Security Council, we discussed a couple of draft laws, we came up with recommendations and so on. But in the end, the draft law is so that the draft law is still there and unchanged. The other draft laws that we consulted and were amended, taking into account our recommendations, brought good results. Thank you so much, but let's give the floor to other panelists as well. Mr. Afanasi. So today we have around 400 cases. If we have to be clear. If PACO draft law is good or not, from my perspective, it's not a good initiative. And second of all, let's not forget that we are the one to execute the laws for our citizens. So let's be careful about that, what kind of laws we have. Mr. Panarli, I will reiterate once again. When we needed certain legal amendments to be done, and we mentioned it, we were heard. When we needed to cooperate with prosecutors, we are aware that both criminal investigation body and many other structures, departments of National Anti-Corruption Center had a good cooperation with them. But in the end, the prosecutor is the one to submit the indictment to court, and our role is crucial because we contribute to the evidence provided by the prosecutor in court. Thank you so much. And Mr. Yakimovsky, you have 1 minute. Yes. I would like the government to take seriously all these changes that they make, and also to take into account the opinions and the recommendations of external partners, to take into account the recommendations of engaged state institutions. And once they do this, then we won't have such statements presented by the Venice Commission when in the report it is stated that for them it's unclear why is there a need to build up a new PACO institution when the current specialized prosecutors' offices are not strengthened enough. Thank you so much, sir. I also want to thank everyone who listened to us. And now we will have break. So there was a joke, the lady said, now it's a break for advertisements. She apologized, saying that now it's a lunch break. Afterwards, we will have another session.
Stimați participanți, vă invităm să luați loc în sală. Forumul Reformarea Justiției și Combaterea Corupției va fi reluat în 2 minute. Stimați participanți, vă invităm să luați loc în sală. Forumul Reformarea Justiției. Stimați participanți, vă invităm să luați loc în sală. Forumul Reformarea Justiției și Combaterea Corupției va fi reluat în 30 de secunde. Participanți. Stimați participanți, vă invităm să luați loc în sală. Forumul Reformarea Justiției și Combaterea Corupției va fi reluat în 30 de secunde.
Good afternoon, ladies and gentlemen. Welcome to the last panel of discussion of the forum. Thank you so much to everyone who stayed with us by the end of this day. We will have a panel of discussion on the illicit asset recovery. Once again, I welcome you at the Forum on Justice Reform and Fighting Corruption that is organized by Legal Resources Center in Moldova, supported by the Embassy of Kingdom of the Netherlands and also the Embassy of France. At the beginning, I want to give the floor to Mr. Octavian Yakimovsky, Senior Legal Advisor at LRCM, to tell us a couple of words about the illicit assets recovery. Thank you so much. It's an honor for me to deliver an introduction. The 2024 statistical data show that APO seized assets amounting more than 1 billion lei, and the amount of confiscations and fees amounts 75 million lei. At the same time, Cox seized assets amounting more than 800 million lei, and fees established were amounting 42 million lei. And these are the statistical data of CARA agency, Criminal Assets Recovery Agency. Based on the notifications received by CARA agency, assets amounting 191 million lei were seized. And here you can see the segregation of it. So the crimes related to these assets were corruption and other corruption cases, money laundering and other crimes. You can see the figures on the screen. Also this year, the Parliament implemented new mechanisms to recover criminal assets that are aligned to international and European standards. Here you can see the seizure applied to third parties, effective property seizure, also seizure on applied to compensate the court expenditures, also planned seizure or forfeiture. Investigations, financial investigations that take place after condemnation or a sentence, and also the forced execution overseas and within the state. The EU Directive 1260 from 2024 on recovery and seizure of actives, of assets from 24th of April 2024 highlight a couple of measures that shall be taken to implement efficiently the directive. And you can see here financial investigations, cooperation between states, seizure, forfeiture, freezing orders, the preliminary evaluation of assets, extended confiscation and confiscation of assets from third parties, also social reuse, appeals methods. Many of these measures are already implemented. At the same time, the EU Regulation 1805 of 2018 on mutual recognition of seizure and freezing orders highlight these 4 types of orders that can be used. The main actor that is engaged in criminal assets recovery is the CARA agency, Criminal Assets Recovery Agency. It cooperates with prosecutors' offices, with criminal investigation officers, with tax authority and foreign counterparts and institutions, and they are very effective in cooperating, especially with European institutions. Thank you very much, Mr. Yakimovsky, for this brief introduction and for showcasing these figures. And now we will record a Vox Populi video to see the citizens' perceptions regarding CARA agency activity. Let's watch the video, and afterwards I will invite the panelists in front.
Cred că acest proces presupune preluarea bunurilor care au fost preluate sau cumpărate din fonduri obținute pe cale ilegală, iar statul preia cele bunuri de la persoana care a înfăptuit o infracțiune.
Данное имущество и выводит его в государственную казну.
Că statul încearcă de undeva să scoată bani, chiar dacă metodele prin care încearcă să facă acest lucru nu sunt tocmai legale.
În momentul în care cineva a prejudiciat statul, populația Republicii Moldova sau chiar și antreprenorii care lucrează pe teritoriul Republicii Moldova și dacă cumva cineva s-a bucurat de un beneficiu ilegal, atunci eu sunt absolut de acord că el trebuie să intre în posesia statului.
Я думаю, что абсолютно нет, потому что очень много, во-первых, имущества, очень много денег скрыто, и мы еще говорим о коррупционных частях, которые, возможно, часть денег просто не доходит до этой казны.
Nu cred. La capitolul corupție noi suntem încă destul de slab, deci nu cred că statul face față.
Nu cunosc date statistice sau o anumită informație obiectivă pe acest subiect.
Nu știu, bunurile astea, parcă și eu amăjeală, nu știu cum. Nu e o nădejde.
Nu știu dacă reușești, că după mine, cum lucrează ei, le-aș pune o notă 2.
Eu m-aș bucura dacă recuperam măcar o parte din ce se fură.
Eu văd că sunt eforturi mari care se fac, adică văd eforturile care se depun și faptul că deja au fost puse niște baze ca lucrul ăsta să se întâmple, eu cred că deja e lăudabil.
Cred că
în primul rând, făcut poate o licitație în care să se vândă casele sau să facă, nu știu, dacă sunt casele extrem de mari, frumoase, pot să facă un muzei, diferite restaurante, ceva interactiv ca să atragă turiștii din alte țări la noi în Moldova.
Они должны как-то эквивалироваться в денежную сумму и отдаваться либо в учреждения, которым необходимы инвестиции, допустим, это образовательные сферы, медицинские сферы, либо также просто в государственную казну для различных пособий и так далее.
Ar trebui să se întoarcă înapoi statului și statul să achite cu populația care au avut de suferit.
Eu cred că ele trebuie să fie în posesia statului și să facă parte componentă din bugetul de stat, care la rândul lui o să fie gestionat în beneficiul copiilor, pensionarilor, oamenilor cu necesități speciale și așa mai departe, care chiar au nevoie.
Și ele trebuie să fie întoarse poporului în diferite forme, de exemplu construcții, renovarea drumurilor, traseurilor noi. Sunt multe lucruri de făcut în țară.
Transparență față de cetățeni în mare parte. Să fie poate nu că doar televizat, dar cumva să se arate că se face acest lucru.
Возможно, какая-то открытая база данных, где буквально каждый человек может зайти и посмотреть отчеты по как раз таки конвертированию и переводу этих денег.
Cât mai multă transparență, foarte puțin ni se comunică despre ce se face, la ce etapă, care este finalul, deci nu prea avem date concrete. E o lipsă de comunicare între noi și stat.
Cred că ar trebui să fie mai transparenți, măcar pe paginile lor de informații.
Este nevoie de cât mai multă transparență, pentru că în momentul în care se anunță acțiunile care se fac, scopul, finalitatea, atunci lucrurile sunt mai clare pentru oameni.
Доверия нет уже, и если... я не знаю, чем исправить это.
Da, așa cum am văzut.
As we've watched in this video, there are many opinions, diverse, distinct ones, when it comes to criminal assets recovery. And now I want to invite here on the stage the panelist of the last panel of discussion. I want to invite Mr. Pavel Kalpajiu, head of the Department for Evaluation, Administration and Recovery of Seized Assets. He represents the CARA agency, Criminal Assets Recovery Agency. Lilian Kishka, the president of the National Integrity Agency. Online is connected Mr. Eliot Macarinelli, magistrate from France. Maria Dergac, lawyer representing Paris Bar Association. Last but not least, Radu Nicolae, the president of the Association for Cooperation and Sustainable Development from Romania. Mr. Nicolae, please have a seat. Thank you so much for being with us today. And I will start with Mr. Kalpajiu, the head of the Department for Evaluation, Administration and Recovery of Seized Assets from CARA agency. Mr. Kalpajiu, my first question is an easy one. What are the challenges, but at the same time, what are the solutions provided by the system to recover criminal assets? I want to remind you that we have 7 minutes for each of you to deliver the speech. Therefore, please be brief to have more time for discussion. Good afternoon. First of all, I want to thank organizers for this event. The recovery itself is a key element when it comes to fighting corruption and organized crime. It's crucial to discuss the challenges with the public in this sector, because the recovery of criminal assets is crucial for the state. When CARA agency was established, it provided solutions to those challenges that have emerged after 2014. There were many questions like why criminal assets from bank fraud case are not recovered. We identified a couple of challenges back then. We realized that we had poor financial investigations back then. We had poor legal acts back then. But also we had many other challenges, simple ones, like how exactly to manage the seized assets, how to preserve them, where to stock them, and so on. Then we adopted the law 48 on CARA agency, and the provisions of that law allowed us to start the work and to have the results today. The agency has been established not long ago. It was established 8 years ago. We cooperate with many institutions. We cooperate with law enforcement bodies, prosecutors' offices, courts, tax authority, last but not least, Ministry of Justice and probationary service. They help us to improve the recovery system. We developed an institutional strategy within CARA agency, and also we developed the national plan for criminal assets recovery for 2023-2027. It was adopted in 2022, entered into force in 2023. During this period of time, we received support from public authorities, civil society organizations. We established working groups consisting of members of civil society. And those messages that I've heard today during that Vox Populi video, these messages were heard for the first time back then. We developed our institutional strategy based on those needs and expectations that citizens have. It's crucial to go beyond this institutional circle and to see things from a different perspective. And this strategy helped us to do so. For the past few years, we are constantly communicating with civil society organizations and development partners that provide crucial support to us. They help us conduct those activities that are included in our action plan. As of today, I will highlight the solutions that we have already have and those measures that we conduct. In 2025, CARA agency implemented the National Automated Information System for criminal assets, a system that allows each institution involved to introduce the data, also to have the access to data regarding criminal assets. This system allows us to increase the transparency of criminal assets recovery process, but also it will improve the institutional memory when it comes to asset recovery. As my previous speakers have mentioned, complex cases, complex criminal cases last in time. And once we end up to execute a certain order to recover certain assets, we need to have a clear understanding what has happened so far until then. Thank you. I do have a short follow-up question concerning what you have highlighted. The data presented by Mr. Yakimovsky show that there is a huge gap between those frozen assets and those recovered assets. So what are the challenges to finally confiscate all the assets? Well, first of all, you need to understand that there is some life after confiscation. Just as a comment regarding that question, is there any life after vetting? So, first of all, we need to have a confiscation order to do it. At the moment, our information system contains information concerning the fact that we executed 2 recovery orders and we recovered 11 million lei from these 2 high-level cases. So in total, we have 150 million seized assets, valuing 150 million. 8 years ago, in January, we started to freeze the assets, and some of them are confiscated right now because the sentences are issued by the courts only now. But you need to understand that these judgments can be appealed, can end up even at the Supreme Court. So it takes time until we finalize the confiscation of the assets. And the second question, why there is this gap between those frozen assets and seized assets? Well, when you seize an asset, it doesn't mean that you right away transfer cash to the state budget. No. The parliament also adopted the law on social reuse of criminal assets. Many criminal assets that are difficult to be traded from various reasons, they will be socially reused, or they will be used according to the needs of the society. Now, the recovery part is a complex puzzle. Each element of this puzzle shall have its appropriate space and place. So this recovery process takes time, a lot of time. Thank you so much for these explanations. And now let's move to the next panelist, Mr. Kiška. Mr. Kiška, what's your opinion about the strengthening capacities between those institutions that cooperate in order to recover criminal assets? How to strengthen their capacities better? Good afternoon to everyone. Thank you, organizers, for this opportunity to be part of this discussion platform and to discuss criminal assets recovery. The mission of the National Integrity Authority is to ensure integrity shown by public officials that hold offices. We assess the wealth and income declarations of public officials and other subjects that shall submit these declarations. There are many other law enforcement bodies that are engaged in this recovery process. Our task mainly is to establish that unreasonable wealth. And the authority is an administrative body. We do not use any mechanisms that would allow us to recover certain assets. So it's crucial for us to cooperate strongly with CARA agency, especially when it comes to certain information that shall be obtained. But our area of work is different. When we make a control of a certain subject, when we identify unreasonable wealth, we finalize a report, we send that report to court, and we request the unreasonable wealth to be recovered. Also, our authority can submit a seizure order to submit it in court while doing parallel comprehensive investigations. In 2025, we registered the first case when our report, our confiscation report, was finally approved, endorsed by the court, and the unreasonable wealth shall be recovered. So when it comes to seizure itself, then the tax authority is the one that helps us to do it. We need the final decision issued by court. We send the decision to the tax authority, and they recover the assets on our behalf. And we also need to mention that this mechanism is not so well established. We still need to identify the gaps. In the nearest future, we will have final decisions issued by courts that will allow us to confiscate, to seize more assets. So our mandate is to seize the unreasonable wealth, and we also cooperate with CARA agency. So we either do it through the support of CARA agency or through those administrative acts that are endorsed by the court, but the idea is similar. Even though we had this final decision issued by the court this year, still it takes a lot of time to finalize the seizure of unreasonable wealth, and it will take even much more time until the state will get the value of those assets back. Our colleagues from CARA agency, they have a broader experience in this regard. We are happy that we have already had the first case. Of course, we want to finalize it, and we want to finally register that seizure. What kind of support do you need from the authorities? What kind of actions shall be improved, provided to you to make you more efficient? When it comes to the cooperation with other institutions, I wouldn't say that we register any bottlenecks. In 2023, the law was amended and it allowed the authority of integrity to send the documents to court and also to submit a request to seize the assets. Now this request cannot be submitted because the administrative procedure does not foresee this thing. Also, this mechanism has recently been amended, and we will be able to submit this request to be assessed by the court and to issue also a final decision concerning unreasonable wealth that shall be recovered. As I've mentioned, we have identified many gaps. We will see how this current case will be finalized. It's difficult to draw conclusions on only having just one case. There is a need for more cases to be registered, to draw a conclusion, to assess the results, and also to see whether certain changes shall be made. We want the objective set to be achieved. Once we register certain gaps, then we will definitely come up with legal proposals to improve the process in order to make the asset recovery more efficient. Thank you. And now we will move to Madam Maria Derkac. From the beginning, I want to ask you what European practices or French practices could be taken by Moldova and adjusted here. You do have an experience as a lawyer in France. Could you please share your experience in this regard? Please, you have the floor, madam. Does it work? Good afternoon, ladies and gentlemen. First of all, thank you for the invitation and for this opportunity to participate in this panel that tackles such a crucial topic, the recovery of criminal assets. I want to show my appreciation towards the quality of interventions and the quality of this event. And when it comes to the question itself, well, I want to showcase best practices, but also the challenges that France experiences. France has an experience of more than 20 years in this regard, but we still have many problems and challenges that we try to solve. A big challenge appears just at the beginning. The recovery process. It's linked to the identification of criminal assets. Huge efforts are made. We have really efficient laws, but in practice, right at the beginning, when the investigation starts, the assets are not identified. There is a need for a year or two to pass until to identify these assets. And of course, when the investigation is finalized, these criminal assets are even better hidden because the criminals have this time, and criminals identify various methods to register those assets on other owners, and it's difficult to identify them. It's difficult to track those assets, especially because we do not have enough investigators. We do have very well skilled and experienced investigators, but the number is not sufficient. And also we do not have sufficient judges very well trained on this particular matter. We still need a lot of work to do in this regard. I think the cooperation is crucial, the cooperation between countries and counterparts, competent authorities. I do know that a French judge will talk more about the cooperation between France and Moldova. I would not elaborate on this topic more, but France tries to improve the cooperation with other countries with whom it has less good cooperation. Recently, French authorities established working groups to cooperate with Saudi Arabia. There are so many requests, MLAs sent, and these working groups will improve the cooperation with those countries with whom historically we had a less better cooperation. I want to mention that in France, a new law has been adopted. Well, it's not actually new, it was adopted in 2021, but according to this law, we are allowed to seize not only the criminal asset, but also to check the wealth in general, especially when it comes to financial severe crimes, for which the punishment is higher than 5 years of imprisonment. In case of such financial crimes, we need to assess the entire wealth of criminals. And also, this particular process is very technical and it requires a cross-sectorial approach. Institutions should work with each other because it is not linked only to criminal law or criminal procedural law, but it's linked to civil law, international law, property law. Judges that are engaged, that lead these cases, are usually specialists in criminal law, but they should not hesitate to cooperate with other judges that are experts in civil law or any other experts. In France, the decisions are not so solid as they should have been. This is the second challenge. The third challenge is linked to the legal amendments and changes. There are many developments in this regard. Last year we adopted a new law on criminal assets recovery. We have new provisions, very efficient ones, but there are many questions, and I want to read one article from this law of 2024 that allows the mandatory seizure of the criminal asset. So this provision is good, but this measure was taken to cover certain gaps that might appear. Previously, the judge had to issue a complementary punishment, but the judge did not have material and technical evidence in the case. And in certain cases, it was difficult to issue this complementary punishment. So the lawmakers made it mandatory. Now the judge is obliged to do it. And it leads to the second problem of this law. We make no difference between the criminal tool and criminal asset. The criminal tool is not always linked to the damage. We should make a difference between the criminal tool and the criminal product. So we develop things in this regard, but still there are so many questions. And France has some problems when it comes to the execution of confiscation decisions. Once the decision is not notified to the subject, the decision cannot be executed. And there was a discussion in France on this matter. How can we overcome this obstacle? In Luxembourg, for example, there is a mechanism that allows them to overcome. They publish all these decisions, all those decisions that were not possible to be personally notified, or the subjects of those decisions when not personally notified. So those decisions are published on the ministry's platform, and this decision becomes valid, and it allows the law enforcement bodies to execute those confiscation decisions. And France is thinking whether to use it or not. I think it's a good idea, but we should be very careful because it could lead to certain risks to procedural guarantees, fundamental rights violation, and so on. We should not solve certain gaps with certain legal, complex and difficult texts. Now, could you tell us what Moldovan authorities could do better to seize and recover criminal assets overseas? What kind of recommendations would you have for them? Yes, of course. We do help other states. Once again, I cannot say much in this regard because the French judge will say more in this regard. But when certain crimes are committed in Moldova and the assets are bought in France, the French authorities believe that they should be directly engaged and to investigate. They usually launch their own investigation and they seize that criminal asset. What Moldova can do in this regard, you can you can recover the assets in civil procedure, not only in criminal procedure. I also want to highlight that it's crucial for authorities to cooperate with French authorities that are always open to support other states that want to do these recovery assets in civil matters. But also French judges are experts in French laws, but they do not have the competence to evaluate the damage caused to another state. And that's the reason why this cooperation between states matters the most. Thank you so much, Madam Dergac. And now we will give the floor to another speaker, Mr. Nicolae. Could you tell us how we can use criminal assets for social purposes, to feel that the society benefits from it? You can also refer to the messages during that video. Thank you. It's a pleasure to be invited for the second time in a row at this forum. I will refer to the last part of the recovery process. What do we do with those assets once we recover them, once we sell them and get the money back, or what do we do with those properties that cannot be traded or sold? Well, the situation is complicated. Once we have some seized assets or some seized money, as Mr. Kalpajiu mentioned, in 2025, 11 million lei were seized. This is what the CARA system shows. As our colleague from France stated, the entire process starts with the identification of those assets. Afterwards, the seized assets are frozen and seized to make sure that they do not disappear. And afterwards, when it comes to international standards, we need to manage the assets. There are certain assets that we need to manage to administrate. RB also, CARA agency has many assets of such. And for example, in Romania, we had cases when the agency did not manage properly the assets, and afterwards they were accountable for not properly preserving those assets and not being able to recover them properly and to get the money back. Then we have another aspect, another step of this procedure is the decision that is issued by court, the final decision that shall be executed. If we manage to execute that decision and to get the money back, or at least to get back the assets, only afterwards we should ask ourselves, what do we do afterwards? We should take into account the international practices and the legislation, the EU legislation. According to the EU laws, these assets, the majority of them, those who cannot be traded, sold, shall be used for social purposes. In those communities where the damages took place. The society should see the results. And this mindset is very often found in these European standards. So it's not sufficient just to sell a criminal asset and to get the money back. It's not sufficient. And as you saw in that video, people want to see some transparency. They want to see what exactly happens with those assets. So there is this clear principle of transparency and their visible reuse for social purposes. It means that the society should see how certain real estate properties are used by the community. More than that, the money that is recovered shall be used to increase the capacity building of those institutions that are engaged in criminal assets recovery. This money should get back to these institutions, to these law enforcement bodies, to purchase equipment, tools that will allow these agencies, these law enforcement bodies, to be more efficient in their work. So in the end, we should show that we achieved some results, and we also should discourage criminals to show the criminals that in the end these assets will be used by the society but not by them. And these assets will be used by communities that were affected by those crimes or by those law enforcement bodies. Although we know that the Romanian justice is experiencing some significant changes, I still believe that Moldovan authorities could learn a lot from Romanian experience. What kind of things, what kind of models can be implemented here? If not Romanian ones, then what others could be? Well, if to put aside the changes that take place now in Romania, and to look directly at this recovery process. We should say that Romania is a good model when it comes to social reuse of criminal assets. We did not achieve much, but still, we had 3 real estates that were reused. So it's one real estate that was given to the penitentiary authority, another real estate was used for social purposes. It's a real estate in Vâlcea, and now it is transformed in kindergarten. For you to understand, that real estate was the actual bribe given to the public official. So now that real estate was recovered and transformed in kindergarten. Also, there is another real estate in Bacău, and we are trying to transform that real estate in accommodation center for older people. Also, we opened a civil society fund. We transfer the money there, and we support the victims of crimes. We support certain projects implemented by NGOs that are funded from that fund. Also, NGOs managed to purchase needed equipment to improve their activity. So there are a couple of examples, not many, but it shows that this social reuse is useful even in our context. Our colleague from France also mentioned how this social reuse can be used in France. The best example is in Italy, where they have already started the social reuse of criminal assets 30 years ago, but this model shall be adjusted to the reality and the context of the country where we want this model to be developed. We cannot copy the Italian or French model. We cannot even copy the Romanian model. We need our own one, and I trust the Moldovan parliament, and I'm looking forward to that draft law to be adopted to distribute equally these sums. Of course, part of the money shall be transferred to the state budget. The same thing happens in France and Spain. A big part of the money is transferred to the state budget, but also a significant part of this recovered money shall be transferred to law enforcement bodies that are part of this recovery process.
Thank you very much. And now let's continue with the last but not latest speaker, Eliot Macarenelli, magistrate from France. I have the same question to you. What is the French model of assets recovery? What can Moldova learn from France's experience, and what would you recommend to the Moldovan authorities on how to better recover and use these assets?
Thank you very much. And I would like to thank the LRCM team and organizer for organizing this event, which is a wonderful opportunity to share views on this important topic. We could see in the video also of Vox Populi that this topic is important not only for officials, of course, but also for the citizens. And so it's very important to address this topic and to have efficient cooperation in seizure and confiscation. So I'm Eliot Macarenelli. I'm a magistrate, legal expert in the Office for Mutual Legal Cooperation, which is a central authority for the Ministry of Justice. And I am in particular in charge of the mutual legal assistance with Moldova and regarding seizure and confiscation. We can see that mutual legal assistance is very important in multiple cases because of the openness of the capital and the faculty of the criminals to have assets abroad and to launder their assets abroad. So it's very important that we all cooperate to effectively recover these assets. It's an issue for preventing the repeat offenses, of course, but it's also a more broad issues of combating impunity and making sure that criminals pay for what they did. So I will rapidly present the French framework for international criminal cooperation. First, let me introduce my office, so the Office for International Criminal Cooperation, the BEPI, which is a French central authority. It is the office that is in France in charge of mutual legal assistance in criminal matters, and it is organized in two divisions. There is mutual legal assistance, which is responsible for all the MLA's requests, and in particular the request for seizure and confiscation. And there is another division in charge of extradition and transfer of person. So the process for transmitting mutual legal assistance requests varies depending on the treaties that binds us with other states. When there is no treaty, the diplomatic channel can always be used to transmit mutual legal assistance requests. And in fact, France allows for the execution of mutual legal assistance on the ground of reciprocity. So there is always a possibility to cooperate with France. In this case, as you can see, so that's the third line in the presentation. In this case, the Ministry of Foreign Affairs is involved as the transmission of information goes through diplomatic channels. Most of the treaties that France signs allows for direct transmission between central authorities. So in this case, the transmission occurs from the judicial authorities to the central authority, which is often a member of the Ministry of Justice or the general prosecutor. And then the central authority sends the request to the other central authority, which then can process it. Finally, the first line that you can see, some treaties and also in the European Union allows for a direct transmission between judicial authorities. So turning to more specific issues of seizure and confiscation, the first issue, as it was also pointed out by the previous speakers, is the identification of the criminal asset and the tracing. So it is very important at this stage to have very precise definitions of the assets, as the confiscation will not be able to go on if the assets are not sufficiently precisely identified. So before considering judicial cooperation, this preciseness of the identification of the assets can be achieved through police cooperation. The problem of this type of cooperation is that most often the information obtained cannot be used as a proof in court proceedings, but what is very interesting in this cooperation is that it's very flexible and quick. So in France, this police cooperation regarding seizing and confiscation of criminal assets is conducted by the Platform for the Identification of Criminal Assets, so that's the PIAC, which is our Asset Recovery Office. And in this context, this platform can give foreign practitioners very extensive information regarding, for example, the number of bank accounts which are owned by certain persons or other types of information. But this information will not be admissible as court evidences when it is shared. When we turn to judicial cooperation regarding the tracing of the criminal assets, so this cooperation is interesting because, of course, it allows for the use as proofs in court proceedings, but it is a bit longer. there are several ways of cooperating, and once again, the legal basis varies in function of the conventions which were signed by France. As I said, in the absence of cooperation treaty, France can cooperate on the basis of reciprocity. However, France is bound by multiple multilateral convention or bilateral convention for mutual legal assistance. And this means that with most countries, in fact, there isn't convention allowing for this cooperation. With Moldova, the convention that we use is a European Convention on Mutual Legal Assistance in Criminal Matters of 15/9, and it is one of the instruments most commonly used regarding mutual legal assistance. Within the European Union, we have the European Investigation Order, which was created by the Directive 2014/41 of 2014, and this instrument is very interesting because it allows for direct transmission from judicial authority to judicial authority, and also there are limited grounds for refusal of execution. So that was for the tracing of the criminal assets. Now we will address the execution of seizure and confiscation decision. So once again, the legal framework will depend on the conventions which were signed, but this principle of cooperation in execution of this decision is affirmed in many multilateral conventions, and in particular the United Nations Convention. In particular, regarding corruption, we have the Merida Convention, which allows for tracing and seizing and then confiscating of criminal assets. This principle is also provided in the Council of Europe with the Warsaw Convention of 2005 on the laundering, search, seizure, and confiscations of the proceeds of crime. So the scope of the assets which can be seized in execution of an MLA varies depending on the instruments that is used, but very often what can be seized is the assets which were used to commit the offense, the assets which are the proceeds of the offense, or the assets which are the corresponding value of the proceeds of the offense. So that's the most common cases, but depending on the convention which was signed, we can seize more or less depending on the convention. In the European Union, we have the 2018/1805 regulation, which was mentioned earlier, and which allows for very extensive seizing and confiscation because there is no limit really to what can be seized or confiscating, as it must only be provided for by the law of the issuing states. So any asset which can be confiscating or seized under French law, for example, can be seized or confiscated in Germany in application of this regulation. So the condition for execution, once again, depend on the legal basis which is concerned. And it is also very often provided for in the convention. However, France has a legal framework which provides for grounds for refusal when it is not provided for by a specific convention. So we have a number of grounds for refusal where the confiscation or seizing of the assets will not be possible unless there is a convention providing otherwise. In the European Union, so it's once again very, very efficient, as there are very limited grounds for refusing this seizing or confiscation of assets. What we see most often as a difficulty for seizing and confiscating assets is that sometimes the MLA is not specific enough concerning the link between the offense and the assets. It is essential that foreign authorities develop this link in their decision and in the MLA, and that they explain how the targeted asset is the instrument of the crime, for example, or is the proceeds of the crime. And for example, when it comes to the value of the proceeds of the crime, it is important that the MLA develops how the proceeds of the crime was calculated, for example. So this is the most often seen difficulties regarding cooperation in seizing and confiscation. Finally, once the confiscation is final, as it was mentioned earlier, the story doesn't end with the confiscation and the confiscation decision, which is final. Then it must be executed, which can come with various challenges. And once the execution of the decision is complete, the question which arises is the sharing of the confiscated sums. So the principle is that the execution states of the MLA decides on the sharing based on its domestic rules. So in France, when we don't have a specific convention, the French Criminal Proceeding Code provides that when the value of the confiscated assets is below 10,000 euros, then the assets are allocated to France. This is due to the fact that the costs in such a case would be higher than the confiscated assets. So there is no point in trying to share these assets. If the value is at least 10,000 euros, then the criminal proceeding code allows for the sharing of the assets equally between the requesting states and France. However, several treaties provide for the possibility of an agreement on the sharing, and in practice, it is very often that there is a negotiation regarding this sharing of assets. This happens in particular when the state is a victim. So when the French state is a victim, we tend to ask for the complete retribution on all the assets. But also when foreign states are victims of several facts, we also accept that all the assets will be returning to these states. In practice, however, assets are most frequently shared equally between the requesting states and the executing state. Finally, so in the European Union, the same principles applies. When the value is less than 10,000 euros, the assets are allocated to the executing states, and when it is more than 10,000 euros, the assets are shared equally. So to conclude, as in many areas of judicial cooperation, the practical modalities of confiscation and seizure in France depends largely on the relationships that we have with the states, and in particular the convention, the Mutual Legal Assistance Convention that applies. In any case, our objective is that of ever-increasing efficiency of this mechanism to effectively combat crimes, as we believe that seizure and confiscation is a very powerful tool to that end. And we are, in any case, at the disposal of foreign authorities relating to this question and to enhance this cooperation. Thank you very much.
Vă mulțumim și noi, domnule Macarinelli, pentru această prezentare exhaustivă a modului cum funcționează justiția pe această
Sorry, thank you very much for your comprehensive description of the French mechanism and system. Please stay with us for the Q&A session. And now I would like to shift the discussions towards the participants. So let's ask the audience if they have any questions. So please raise your hand if you have any.
Matan from the Basel Institute. I have a comment and then a question, if that's okay. The comment is this: social reuse. What we're really talking about is how we divide up a cake, the cake being the confiscated assets. The trouble is, in most countries, and Moldova is no different, it's on a cake. It's a very small biscuit. It's very, very small. In European Union, 2% of assets are frozen, 1% is confiscated. So we're arguing about a very small amount of money. And one of the reasons that the amount is small and that organized crime is laughing at us is because we don't have the resources. Pavel, you mentioned it. You don't have enough resources. You could do with accounting firms to help you. All kinds of things you need across law enforcement to get confiscations, to get convictions. The only way this is going to change is if we massively incentivize law enforcement agencies. The gentleman from Romania mentioned it as well. I believe it's 30% under the latest law in Romania. If we don't run this like a business, we will not succeed in taking the assets, and without taking the assets, we cannot destroy organized crime and corruption. They are laughing at us. Now, the only two countries where the figures year on year are growing are the United States and the United Kingdom. Why? Incentivization of law enforcement in the United States is 80% under the federal provisions, 80%. United Kingdom, it's 50%. What does that mean? It means prosecutors engage with confiscation. In most countries, it is an irritant. As an ex-prosecutor, it was an irritant confiscation. We were not focused on it. In Moldova, the confiscation figures are low. You have extended confiscation, it's been used twice. It is not the focus of prosecutors. The only way to do it is to make them do it by seeing a massive input into their budgets, so it's worth their while doing it, and they then increase all of the resources that they need. That's my comment. The law was initially 60% was going to law enforcement. It was dropped to 10% in the cabinet between 10 organizations, so 1% each. Laughable, utter nonsense. Now, there is at the moment some work being done, if I can say, by the EU, by other partners here, to get it back up again. It's really important. Otherwise, we will have this same discussion next year and the year after. We want to talk about splitting up a cake of criminally obtained assets to give to the public, to give to civil society. We have to increase it from a biscuit to a cake. We have to do the work, and we have to incentivize law enforcement. First thing. My question, sorry, it was a long comment. My question is to Nia. At what stage during your investigation do you refer a case to NAC or APO for a criminal investigation? Because obviously your conclusion of unexplained wealth is the criminal offense of illicit enrichment. So to what extent do you work together, and when do you refer the case to the criminal bodies, agencies, who would then take the money under their own confiscation provisions under the criminal code?
Thank you very much for your question. I think we will start with Mr. Kishka and then Mr. Kalpajil. As I have already mentioned, we are an administrative institution, and we do not send the cases to the National Anti-Corruption Center or to APO. According to the law, we establish unexplained wealth, and while it is examined in the court, in parallel we submit a confiscation request. And when this request is approved, we use the existing mechanism. We send a request to the tax authority with the list of the identified assets. And the tax authorities have the competence to confiscate it for the benefit of the state. In case of criminal elements, of course, we send the case to the competent authority, but for unexplained waste, we do not have any mechanism to cooperate with the crime assets recovery agency, because they are dealing with crime assets, but not with unexplained wealth, because unexplained wealth is part of the administrative law. Thank you very much, Mr. Kalpajiu. The question is, how do we transform the biscuit into a cake? So what should we do for prosecutors to be motivated to work in this area? Thank you for your question. David, thank you for supporting the efforts in the recovery area. Recovery efforts are about money, and when money are shared, I believe some challenges emerge. And the draft law that was passed in the first reading showed these difficulties. What should we do to have more to recover? As I've said previously, social reuse is a very important element, including as a motivation to ensure continuity, to make sure that this recovery mechanism works well. As the French lawyer has mentioned, recovery starts with a criminal investigation, assets tracing, then it continues with the efficient management, preservation of the value of seized assets, and then international cooperation or representation in the court, and last but not least, court examination, who have to issue the confiscation decision. After that, a tax authority or recovery agency steps in. And here, if all of these elements work together, then we will have this biscuit transformed into a bigger cake or into several cakes even. So there are not safe solutions in the recovery area. On the other hand, in Moldova, it is the public authorities in charge of recovery efforts, and each public authority needs to contribute with each expertise and competencies to this concept. Regarding how confiscated assets should be distributed, we had many discussions, many debates on this topic. Last but not least, I believe that social reuse, but not public reuse, I mean social reuse, and the projects that have been described by our colleagues from Romania are very important. And I believe that the civil society has to participate in this process as well, because the message that we convey to the society can be amplified by the civil society. So civil society can become a major stakeholder in this area. Mr. Nicolae, maybe you would like to share your opinions. So what would be the best, the most appropriate model for the Republic of Moldova? And maybe we could discuss what would be an appropriate percentage. Yes, indeed, the end goal is to convert the biscuit into a cake, but to do that, we need to have strong prosecution offices, some legal mechanisms to operate efficiently. There is no country in this world that would say that everything is perfect. And these percentages of 2% and 1% are actually true. And if in the Republic of Moldova we have more than 50,000 euro, in Romania we'll see just a couple of million euro. And the differences are not that big. And I feel, at least when talking to prosecutors in Romania, they are so worried. Their major preoccupation is to collect evidence in order to send them to court, so that the court accepts them. Because in Romania, there is a saying that it does not really matter how many evidence you collect, there is always a risk that you will fail in the court. To give you the well-known case Nordis, where a developer sold the same apartment to 5-6 people, the seizure was applied, and the court said that the seizure was checked in one day. So you have to check if the seizure is still relevant, if grounds for seizure are still in place. So this verification is done by the prosecutor, and the judge lifted the seizure because of this delay in 1 or 2 days. So these are small details which of course do not present any interest for the public, but if we are to analyze how prosecutors work, how they cooperate at the international level, the French judge has presented the international regulatory framework on the basis of which we cooperate. But if we are to analyze the cooperation in details, you'll see that there are many small things that does not help us with securing an efficient seizure and confiscation abroad. And all of these small elements keep on cutting slices from our cake, and in the end we end up with a small portion of the cake. So I believe that the discussion that we had in the previous session is very relevant for this session's discussion, because in the previous session we discussed how to enhance the capacity of the prosecution office to make sure that they manage well their cases. Thank you very much for your comment. Would you like to add anything? If not, let's continue with the next question from the audience. I have 2 very short questions. I was asked to stand up, sorry, okay. 2 very short questions. One for Maria. You used this notion of ciphering. I know that these are qualitative arguments on the civil part, but can you give us an example of a successful case? What are the elements of such a case? And the second question for you, about negative experiences and positive experiences when the crime asset is in cryptocurrency, or we don't have any experience there and it's totally beyond our...
When we consult a state, that state will share with us various documents that prove that in their state a certain crime was committed, and the money, the criminal money, was used to buy an asset in France. What we request from the authorities of that particular state is to provide financial documents, because we need to provide that figure, that number to the judge. Look, we have this financial report or this analysis that shows that the damage amounts this figure. The judge will examine the documents, the acts, and will decide whether the figure is appropriate or shall be reduced. But we indeed need such a document that shall be provided to the court, shall be provided to the judge for them to take a decision in respect to that damage. And the second, how can we recover crypto assets? How we can get the money back from crypto assets? Thank you so much. We call it, so we say like this: the positive results we call success or achievement, and the bad experience just experience that should be improved. Our CARA agency does have the capacity to conduct financial investigations that include cryptocurrency according to the provisions of Law 308. The first crypto seizure was done by CARA in 2020. That was a case investigated by General Prosecutor's Office. At the moment, we have cryptocurrency seized amounting 4 million euros. More than that, CARA administrates this cryptocurrency. We do have electronic wallets in various cryptocurrencies. There are 62 cryptocurrencies in total that we have in our wallets. When it comes to the challenges, we do understand that criminals migrate from bank accounts, from cash, to virtual world using illicit funds. The illicit funds use cryptocurrency. This is a phenomenon that will be continuously developed, and here in the country we should develop financial investigation tools within CARA agency, but also within many other law enforcement bodies. It's not sufficient to have only 2-10 specialists trained at the national level to cope with this phenomenon. On the other hand, we have more seizures on cryptocurrency that was done by Yaloveni Prosecutor's Office. So this is a territorial prosecutor's office that had investigations because they have this specialist, but once the prosecutors across the country are supported by experts, they will be able to do so. We closely cooperate with territorial prosecutors' offices, with border police, with police inspectorate, and that $5 million that we have in our system, the biggest part of this money was seized from cryptocurrency, thanks to the engagement of border police and police inspectorate. From my perspective, the law enforcement bodies are doing very well. What we should do next is to multiply this practice. There is still room for improvement for such investigations. We do need the support of development partners. CARA agency also has specialized tools that allow us to investigate cryptocurrency transactions. These systems, this software are extremely expensive, but development partners helped us to purchase them. CARA agency also cooperates directly with crypto platforms that trade at the international level. So once we have this formal cooperation through MLA, then we also have informal cooperation through various platforms like Amin and others. But besides this, we have the third way of cooperation with these cryptocurrency platforms. 38% of cryptocurrency transactions are done via Binance platform, which means that we need to increase the capacities of law enforcement bodies. I am optimistic in this regard. Mr. Kalpaju, recently the authorities identify a USB stick that had 107 million US dollars in cryptocurrency. This USB stick was identified when those pre-electoral investigations have been conducted. Could you tell us more about it? Well, Kara agency has been trained in this type of investigations, to lead this type of investigations, but I cannot give you more details than that. Well, I tried my best. I understood that this is an ongoing investigation and you cannot give us more details about it. Now, sir, could you tell us more, could you tell your point of view in this regard? What can we do more in this matter? Well, first of all, we need to be capable to lead good financial investigations that will help us to identify this cryptocurrency. I think, first of all, specialized prosecutors' offices should be trained how to identify cryptocurrency assets and to identify where there is such a potential. Also, we need to improve the legal framework, Moldovan legal framework in terms of cryptocurrency. Many states have already made some developments in this regard. I do understand that you have had many discussions how to amend the law on cryptocurrency. Well, Romania is not far away from Moldova, and to make a transaction there, it's not so difficult for criminals. Like it's easy for them to migrate and make transactions there. Well, this is a comprehensive field. Not only Kara should be engaged, but also the National Authority for Integrity shall be engaged. And just to refer to Mr. Kishka, these cryptocurrency assets also could be a reasonable wealth. It's just interesting how exactly we can identify them, and are there any cases of subjects declaring these cryptocurrency assets in their wealth declarations, and what do we do to make sure that they declare it? Criminals in general are very well prepared to identify the vulnerabilities of the system and the strongest part. So we need to strengthen our capacities to cope with them. The technology develops at such a speedy rate, and yes, Binance is one of the most important actor on this market, but this is not the only one. So these cryptocurrency assets could be hidden by many other platforms, or any other platforms could be used in this regard. Thank you. Mr. Kishka, the investigators within your authority, do they have needed capacities to investigate such transactions? Well, it's indeed. This is a new reality that we experience. Even the declarations that are submitted by the subjects, the wealth and interest declarations, contain a separate chapter concerning cryptocurrency. The subject, once having it, shall declare and complete that chapter in the form. They also need to include when exactly they acquired and traded the cryptocurrency. Also, we included a section where they should include the key. We needed to be able to track that cryptocurrency. Our inspectors participated in comprehensive training on using open data sources and training on identifying a cryptocurrency. We do have some tools in place that are used. We will see how well we are capable to track the cryptocurrencies, because our final objective is to identify whether the subject itself had the needed financial means to acquire the cryptocurrency that they have. And once we identify the cryptocurrency or we identify this unreasonable wealth, we need to know what kind of measure shall be taken in this regard. For us, this particular subject is something that is not very well handled. We are still studying it. We are trying to increase our awareness when it comes to this subject, but you know, the technology is developing at such with such speed that we cannot cope with it. Thank you so much. So you have mentioned that you provide regular trainings to inspectors. Yes, if you allow me, can I comment? We do have good cooperation with CARA agency and FIU. We exchange our experiences, what kind of identification methods we use, because it's one thing to identify these criminal assets. CARA agency investigators have greater experience. They also cooperate very well with Binance and Bybit platforms. They have this strong cooperation, and through them we ask these platforms to get more information. Are there any other questions in the audience? If there are any other questions, let us know. Please raise your hand, introduce yourself, and address the question. If you don't have any questions, you may have comments, so please be brave. There are no other questions, and I will ask Madam Derkac. In 2022, France seized a villa that belonged to Vladimir Plakhatnyuk. It amounted more than 4 million euros, and the Republic of Moldova is trying to recover this asset since last year. As a lawyer who handled these particular cases, what kind of decision should we expect? And will it be possible to recover the value of this asset? I don't remember exactly where this villa is located. It's somewhere in the mountain area. Well, I read in the media about that seizure. It's a temporary seizure. It's not confiscation. It's not confiscated yet. We will wait for the decision of the first instance court. It will take a couple of years. The French court won't issue a decision so fast because many investigations shall be finalized. Also, it depends on how well Moldovan authorities will cooperate in this regard, because Moldovan authorities could bring additional information and this procedure can be accelerated. Maybe they could bring additional evidence. I don't know the exact details of this criminal case. I cannot say much. Even if I knew, I wouldn't be able to tell you much about this ongoing criminal case. For sure, it will take many years. And after the decision of the first instance court will be issued, that decision will be appealed. We will wait for some time. The appeals could take like a couple of years, and afterwards is and then so it will take some time. We just need to be patient until it will be closed. Thank you. Are there any questions? Because I don't want to monopolize the discussion. And now I want to refer to Mr. Kalpajiu. I want to refer to SURE, a criminal organization, and Plahotniuk criminal organization. How do you handle the assets, the criminal assets that belong to this group? Did you manage to recover many assets in this regard? These two criminal cases that generically are part of the bank fraud case. These cases are handled by the Anticorruption Prosecutor's Office. Our agency does parallel financial investigation. I cannot give you more details, but the case prosecutor can give you more information in this regard. When it comes to SURE, I can give you some details. SURE was sentenced, and he has to pay a damage amounting 300 million lei. Also, a Bentley vehicle amounting 200 million euros was seized, and the bailiff is selling this Bentley for 50,000 euros. So if someone wants to be an owner of such a Bentley, so you can become an owner by paying just 50,000 euros. Yes, we are the recovery agency. Of course, you have all the right to buy such a vehicle. Also, Ilan Shore had a couple of apartments. They are for sale now. When it comes to post-sentence confiscation, well, this is everything. But many other details on these criminal cases can be delivered by the case prosecutor. Thank you. Mr. Nicolae. So once the state will manage to recover the assets linked to these two criminal organizations, what kind of signal, what kind of message will it be shared with the society? Well, first of all, these assets definitely should be confiscated and recovered. What I would underline here regarding to what Mr. Kalpajiu has made. Well, besides the marketing or this advertisement that was made, we need to do this preliminary trade. What it means, we should not wait until the moment the asset loses its own value. We should recover these assets quickly to preserve the value of those assets. So we need to recover them as quickly as it's possible to get the money back. Plus, it's good to remind the public that, for example, the UK sent seized money from Luca Filat. So the money seized from Luca Filat was sent back to the Moldovan authorities. 600,000 euros, if I'm not mistaken. Yes, exactly. So that was an unprecedented case, because this money was used to support people with disabilities, to pay the wages of social workers that support these vulnerable groups. So this is a good innovation. So the money was returned. I do understand that it will be difficult to recover 1 billion, but still any money recovered is good. This huge fraud is so complex, and any money recovered is a great achievement for us, and it shows that the authorities work. Are there any questions? If not, then I have a question for Mr. Kiška. It is well known that prosecutors and judges from Moldova, they are owners of assets in Romania. Some of these assets are declared, some of them are not. Now, are you going to establish a partnership with Romanian counterparts, with the National Agency for Integrity in Romania, to recover or to have a clear value of these assets? Well, we do have a great cooperation with our counterpart, but the Romanian counterpart does not have public registers. And if certain information is needed, then they need to request the access to register, but they have no right to disseminate this information overseas to other. We are using other information exchange mechanisms like MLA. Unfortunately, we have only one agreement signed so far with the Regional Anticorruption Initiative. We signed an agreement that allowed us to have this information exchange between Republic of Moldova and Balkan countries. But this agreement is ratified only by 5 states at the moment. But unfortunately, our subjects do not have assets in these 5 countries. When it comes to Romania, well, it's a sensitive topic. Even though our subjects have certain assets in Romania, they owned those assets using their Romanian citizenship. And we need other mechanisms to obtain that information. Romania is a European state. The GDPR is implemented there and imposes many restrictions when it comes to the exchange of personal data, sensitive data. But we try our best to get this information. When the subjects declare these assets in wealth declarations and we do the assessment, we check whether the subject had needed resources to allow him or her to buy that asset in Romania. If it's proven that they had needed resources to buy the assets, then we cannot do anything more than that. Only when the National Integrity Authority does an analysis that shows that the subject did not have enough sources to buy an overseas asset, only then I try to get information from overseas. We had such cases. We got the information concerning certain overseas assets, and we included those information in our reports. But once it is justified that the subject did not have enough financial resources to buy the assets, then we try to track the assets and seize them if it's possible. Now, Mr. Nicolae, I know many people, many subjects that have assets in Romania. They did not declare these assets. Tell me, please, how can Romanian counterparts cooperate better with the Moldovan counterparts to be more efficient in this regard? You know, systems from both countries have their own limitations. It's difficult to say what exactly Romania can do more after the fact that the Constitutional Court issued this year that these wealth declarations can no longer be publicly available or published. But at least the minimum transparency should be guaranteed in Romania. Romanian citizens at least should have access to certain information. Therefore, I think Romania has just a few good practices to share in this regard. Maybe in the past we had more and there was this willingness, but now what can be done? Well, if there is a false declaration and there are some leads that show that the subject has assets overseas, I think that it's possible to identify some innovative methods, like to cooperate with the CARA, with the FIU in Moldova, to collect needed information and to support the activity of the National Integrity Authority. If indeed there are such assets and were not declared, then for sure we can diversify the mechanisms that allow us to have access to information and not to limit ourselves only to some administrative investigations. Mr. Nicolae, in this regard, we should highlight that our subjects hold assets in Romania, they are owners of assets in Romania as Romanian citizens. Again, we have a limited number of subjects that we investigate, like members of the parliament, public officials, and so on. The biggest problem in this regard is when our subject has double citizenship and owns an asset in Romania using their Romanian citizenship. So the law should be amended. No, it's not about the law. The law allows us to verify the assets of the subject, but if the wealth of the wealth of the subject is linked to the citizenship in another country, this particular subject has other citizenship, and we have no mandate to do more than that. The subject is obliged to declare these assets. When we ask from our overseas counterparts to provide information regarding those assets, we are told that personal data of their own citizens cannot be provided to us. If our colleagues from CARA agency have agreements, cooperation with the various platforms, and they can get much more information, we are limited in this regard. But we are trying our best to do our job well and to achieve our objectives. Thank you.
So we have 5 minutes left, so I kindly invite panel speakers to make a brief conclusion, no more than 1 minute. What should we do to improve the crime assets recovery? So, if we focus on the competencies of the authorities only, my opinion is that once the ice has been broken, I believe that the confiscation and seizure mechanism will continue working. So, if this mechanism turns out to be cumbersome, then we will think how to improve and refine it so that we can track and seize and confiscate assets for the benefit of the state or their counter value. And also, we have to find a way to confiscate these assets quicker so that their value is not affected, or for the subjects not to manage to dispose of those assets. Thank you, Mr. Kalpazhiu. A brief conclusion. Thank you. I'll be very brief. I hope so I would like to wish lots of dedication and to the relevant authorities. Hopefully they'll have transparent interactions, integral process, and sound decisions. As a conclusion, I would like to say that the crime assets recovery mechanisms is one of the most efficient tool that we can use to fight financial crimes and corruption. And as I've already said, it depends on efficient investigations that should be done from the very beginning. And also we need to make sure that the stakeholders involved in this process have the needed capacities and skills. We need to have interinstitutional cooperation, international cooperation, and it is necessary to find a balance between crime assets recovery mechanisms and observance of the fundamental rights, because only in such a way we can have a both legitimate and trustworthy system. Thank you, Mr. Nicolae. I think that the Republic of Moldova is making progresses for a couple of years already, but we have not yet reached the point where the process has become irreversible. So we have to be attentive to any legislative amendments to make sure that the institutions, the prosecution offices, the Crime Assets Recovery Agency, National Integrity Authority become stronger and stronger. Maybe the progresses are slower compared to the expectations, but this should not discourage us. This should not make us give up. We need more courage. We need more public communication, including the communication around the small biscuit that we managed to recover, because this is a progress as well. It shows that we are walking in the direct direction. If you're still with us, Mr. Macarinelli, please formulate your conclusion.
I think one of the key issues is the swiftness of the international cooperation, because of course the assets can move very quickly. So I think one of the main point of attention is increasing the swiftness of this cooperation. And I believe this can be achieved by multiplying the contacts between foreign authorities, so that we can better understand each other's systems and know each other. So I think that's one of the main points which will allow us to be more efficient and more quick in this confiscation and seizing of assets.
Vă mulțumesc frumos, domnul Macarinelli, și pe această notă pozitivă aș vrea să închidem.
Thank you very much, Mr. Macarinelli. So we are finishing this session with the accuracy, almost the accuracy of a Swiss clock. But please do not leave. We have a coffee break and then conclusions formulated by the organizers of this forum and my colleague who will moderate the last session, Liliana Barbaroshi. Thank you. Have a great evening.
Paneliștii noștri.
Stimați participanți, vă invităm să luați loc în sală. Forumul Reformarea Justiției și Combaterea Corupției va fi reluat în 2 minute. Stimați participanți, vă invităm să luați loc în sală. Forumul Reformarea Justiției și Combaterea Corupției va fi reluat în 30 de secunde.
Doamnelor și domnilor,
Ladies and gentlemen, welcome back. Good evening. We have reached the end of an event that was intended to keep into public attention the situation in the judiciary sector, in justice sector. For 2 days, we have had the forum Justice Sector Reform and Fighting Corruption. During this forum, we have discussed important topics for strengthening rule of law, and we have also addressed what should be done in order to increase people's trust in the judiciary. Justice sector is always monitored by EU, and reforms should always continue in order to have sustainable results in the accession process. It is not by chance that the EU accession negotiations start and end with the justice chapter. So let's make a summary of 2 days of work. Forum organized by the Legal Resources Center in partnership with the Ministry of Justice and supported by the Netherlands Embassy to the Republic of Moldova. So let's formulate some conclusions together with the President of Legal Resources Center, Mr. Ilie Chirtoacă, and the Deputy General Secretary of the Ministry of Justice, Stella Braniște. Who should start, and what are the conclusions, what are the key takeaways from this forum? Good evening, Mrs. Ursu. Good evening to everyone. I have the role of making the conclusions on behalf of the Minister of Justice and the whole Ministry of Justice. So we had 2 full days of discussions that focused on justice sector reforms, anti-corruption policies. These are essential areas of our work, not only in terms of the government's priorities, but these areas are significant and essential for a genuine rule of law and for gaining people's trust in state institutions. I would like to congratulate the Legal Resources Center for the comprehensive agenda. We had representatives from the judiciary, civil society, journalists, and the discussions focused on priorities, achievements, prospects, as well as drawbacks or needs that require improvements both in the justice sector and in particular state policies in the law area. Yesterday and today we've spoken about integrity, transparency, dedication, accessibility, and these are the very elements of rule of law that Mrs. Valentina Ursu referred to when opening this final session. What should be done next? So we know what was done. We had the possibility to think, to ponder, and now it is time to make conclusions and set prospects for the next period. So, speaking about rule of law, for sure, all of the participants, both in person and online, have heard about Rule of Law Index with a lot of curiosity, and I would like to thank World Justice Projects for their presentation. We are glad to see that Moldova managed to climb in the ranking of Rule of Law Index, but there are still areas where efforts need to be invested. In 2024, in the autumn of 2024, when the Republic of Moldova was subjected to bilateral screening by European Commission in Brussels on the functioning of democratic institutions, we had a presentation focused on the democracy framework in the Republic of Moldova. And I spent a lot of time to find Rule of Law Index. I found the ones that were valid until 2023, but they did not look well. But the figures I've seen yesterday, I like them very much. They can be presented to the European Commission. So now we have this strength. We can use it when we have more frequent discussions with the European Commission. And I'm sure that in 2026 we will manage to show our progresses. So what should be done next? From the perspective of the Minister of Justice, in the agenda we have the development of a new strategy paper for the judiciary. I do not like to use this expression justice sector reform, because as a public official in the Ministry of Justice, this word or this expression justice sector reform was used too often, and I think that everybody is tired of this. So I believe that further on we have to call our efforts justice sector strengthening, because in the future we will not focus on reforming but on strengthening the justice sector. We will not focus on legal amendments, because these are not the most necessary thing to be done now. Our focus will be on strengthening the institutions. The ministry will pass by the end of 2026 a new strategy paper for the justice sector. And I would like to urge all of the participants here to engage in the work on this strategic paper. So we would like to work in close and strong cooperation with all of the relevant stakeholders in the judiciary, judges, prosecutors, legal professions. And we need the expertise of the civil society, the studies and experience that was formulated by the civil society will be the cornerstone and will help us shape the future strategy. In the first quarter of 2026, the ministry should put up for consultations and public discussions the first draft. Of course, as it was mentioned yesterday, this draft concept paper will include all of the priorities of the judiciary and aspects deriving from our commitments as part of EU accession path. We have the roadmap, we have a reform agenda that was negotiated and agreed with the European Commission, and all of these priorities will be reflected in this strategy paper. So I would like to encourage our partners from the civil society and our development partners to participate actively, to come up with suggestions and recommendations so that finally we have a better document than the previous two strategy papers in this sector. Another priority that I would like to highlight is the need to join our efforts in order to strengthen the capacity of national authorities. The deliverables expected by the European Commission are related to figures, track record, as it is formulated in the roadmap, in the reform agenda. So we need to focus in the future on justice sector stakeholders, the capacities of which are strengthened, which have all of the needed tools, that have trainings, information equipment, because all stakeholders need to produce the expected deliverables. In the anti-corruption segment, we need to have final decisions on large-scale corruption cases. And of course, all of the stages are covered here: investigation, sending the case to court, court examination, and so on. We should also increase the case resolution rate, and we need to decrease the case examination duration. Because there are still pending cases, so we need to find solutions in order to decrease the backlog and to increase the settlement rate, case resolution rate. Also, we would like to make sure that stakeholders have a high level of integrity, stakeholders that are trustworthy, stakeholders that are protected, because unfortunately yesterday speakers referred to risks that certain stakeholders from the judiciary have to cope with while exercising their mandate. So we need to think about tools that we can use in order to protect them, so that people can work with dedication and in a safe manner. So yesterday's and today's discussions have clearly shown that there are no simple solutions in these areas. These are complex areas that require devotion, commitment, time, and money. Another challenge in the medium term and long term, because we speak about the efficiency of the justice sector, so digitalization is a medium to long-term priority. So we need to make sure that the needed investment is made by the state. So the ministry has established a digitalization council, and we would like it to meet often in meetings. The program will be approved soon, and we would like to start its implementation to speed up or streamline processes in the judiciary. Justice sector should enjoy investments, should have enough resources, so that in the medium and long term it becomes accessible, predictable, user-friendly, and all of these elements eventually are reflected in the general rule of law index and should convey the perception of trust and transparency. At risk of repeating what the previous speakers have said, both today and yesterday, justice sector is one of the most complex. As Mrs. Ursu has mentioned, it is one of the most complex negotiation chapters. The progresses and dynamics of all processes, violence, knowledge, impacts the dynamic in other negotiation chapters. When we speak about corruption, European Union has high standards for anti-corruption policies, and long-term plans and outlooks require joint effort, total dedication by all relevant stakeholders. But we have seen them yesterday and today participating in this forum, so that we have a joint vision. Yesterday and today, the discussions were supportive. Also some criticism existed, but criticism is needed also. Constructive criticism is needed if we want to have an efficient and sustainable process, in particular in the justice sector. Of course, I will leave time for Mr. Chirtoacă to come up with his conclusions. So he will present his conclusions regarding anti-corruption policies. But I would like to reiterate, it's a fact for us to advance in an efficient manner and to keep up with the ambitious deadline set by the government for the European integration. We need engaged institutions, dedicated stakeholders, available financial resources, clear visions, and political will, political support. Because we do have dedicated stakeholders that are developing and implementing policies, and I believe that step by step we'll manage to progress and achieve the set goals for all chapters and sub-chapters. That is all. Thank you very much, Stella Braniște, Deputy Secretary General of the Ministry of Justice. And now I'd like to give the floor to President of Legal Resources Center, Mr. Chirtoacă. Could you please tell us how this 7th edition differed from the previous 6 editions of the forum. Thank you for your question. I strongly believe that in 2019 we were only discussing some ideas that are being implemented now. So I cannot dare to say that this forum is the only discussion platform, but it is an important platform where certain ideas are tested, are discussed with relevant representatives, so that in the 7th edition we are already discussing about the final stages of some reforms. To give you some examples, in 2019 we were discussing vetting as a concept idea to be applied only to certain subjects, and now in 2025 we are discussing about, well, I would not say a process that has reached the mid-level of implementation. I think it's about 2/3 of implementation. And here, thanks to some forum on this forum, we discussed how some of the processes can be improved. Another idea that has been discussed a lot, and unfortunately in 2025 we are still discussing it, it's a fight against large corruption. How do we share the scarce resources of the Republic of Moldova to make sure that the investigations are efficient and impactful, so that we have the track record as, that EU requires. But if I am to choose only one objective of this forum, it would be the fact that it is a discussion platform. The European Union, among the first recommendations when the negotiations were opened, one of the recommendations was to engage the civil society to organize public consultations in a way that the decision-making is inclusive. So I believe that the forum meets this requirement, and thanks to the openness of the Minister of Justice, we can have these discussions at a high level, and we keep track of what was discussed. After each forum, a position paper is developed. So if I am to analyze, so if we put all of those position papers in a single folder, we can see the itinerary of certain reforms, and we can see where more progresses should be made. So that would be my answer to your question. I would like to continue an idea raised by the Secretary General about the need to join our efforts and political will. During the first day of the forum, the first persons of our state reconfirmed that justice sector reform is a priority. And of course, people form an impression about the reform, taking into account the results, not the intentions. But there is alignment of the main institutions to have this shared reform vision: Minister of Justice, government, parliament, and presidential office. I was glad that development partners, ambassadors came with a political support message as well as technical support message and presented clear expectations. I have remembered well a message about democratic resilience and civic space, because we come from NGOs. So it was said that if there is media freedom, if there is enough civic space to discuss freely, this is another indicator showing that reforms in the justice sector work, because a country cannot have a true rule of law without transparency and space for the civil society. Another strong message I would like to reiterate, it was mentioned on the first day, so I will quote the Minister of Justice. He said that in the justice sector, the minimum standard is 100%. It's not 80, it's not 20%, it should be 100%. Because sometimes one case is too much. You can do a lot of good things, sound policies, but if you have a symptomatic case that shows that the justice sector failed to deliver, then the whole public perception will be affected. I will not focus on digitalization now, but I was glad to hear the main decision makers saying that we're not discussing about the need for digitalization. What they're focusing on in their discussion is what to do in practical terms in order to make progresses. And I would like to reiterate a statement made by the Deputy Secretary General that digitalization can provide a lot of advantages. Moldova is ahead of a number of states member of the Council of Europe. We are in top 20 countries, but perhaps the most mature message was the winner is not the institution that has this application. The winner is the whole system that is aligned. It means that it is necessary to secure a good interoperability of systems. Regarding vetting, we discussed whether there is life after vetting. Yes, there is. At least this is the statement made by panel speakers during that session. Many of them passed through this exercise, and what is happening next, who will take over the responsibilities. Do we need a full vetting or maybe not? We have not found answers to these questions, but we've heard the arguments of authorities who presented the limitations that are currently in place, and maybe we'll find a way to identify solutions. So, starting from the limits identified, we can continue the discussions, we can talk to development partners to make sure that this major effort, including a huge financial effort that was invested in the vetting process, will not be lost. Of course, vetting is not an end goal. The end goal is to strengthen the institutions in the justice sector so that they can deliver results. In the anti-corruption area, we had a very interesting discussion during that session. Decoupling produced many changes, but all of the institutions involved come with the message that they cope with the situation. Some of them have even progressed. We had some statistical data which confirmed at least the criminal cases sent to court have doubled in number, as reported by some of the authorities. But there is still a huge pressure, and they have to learn on the go. At least the prosecutors have to learn on the go. Decoupling versus critical evaluation, PACO process, whether the legal opinion of the Venice Commission is good or not. So each institution has its own interpretation, and these interpretations differ. But it's clear that the fact that our institutions is requesting the legal opinion of the Venice Commission is a sign of transparency. So it's good to consult the decisions with international fora before taking them. And this is important for transparency. That's important in order to improve the document and to make sure that the vision is based on standards. And I am glad that we have managed to address this as well. crime assets recovery. Perhaps it was the most interesting panel in terms of preparation. I was pleasantly surprised to see that authorities of the Republic of Moldova have a know-how that can be shared with other countries as well, including in areas that are only developing. There are good examples and models need to be adjusted. There were many ideas. It would not be fair if I would not list all of them. But what I want to say is that every year we prepare a brief summary where we make a summary of the discussions that were held during the forum. But I believe that the biggest takeaway of the 7th edition of this forum is that the trust is not declared, trust should be gained. And this was said by people in Vox Populi. Though we can say that the justice sector is very complex, nevertheless, there is a very good understanding among our people, and we have to listen to them. Coherence goes above fragmentation, and I am glad that we have a joint team that requires an interinstitutional cooperation. That was the leitmotif of a number of sessions, and I believe that it was reiterated during the closing speeches. It does not matter how many institutions we have, irrespective of their duties. A clear message is that unless there is an interinstitutional cooperation and good governance, we will not be able to deliver results in justice sector and anti-corruption area. And to make the reform more coherent, more transparent, we have to discuss it in a professional and realistic manner. And again, I would say that this is the biggest value added of this forum, these professional discussions between different institutions that sometimes have different opinions, but it's important to discuss them and reach a common vision, because if we truly want to join the European Union, and I do believe that we want it, so irrespective of our role, myself in the civil society, Secretary General in the ministry, other stakeholders, I believe that we have to work jointly in order to succeed. Thank you very much. I would like to hear your opinion, Mr. Kirtaki, because justice sector reform is monitored by the European Union, by IMF. I am reading a section of the press release of the IMF group in the Republic of Moldova. So regarding governance and structures, it states progress in anti-corruption is uneven, with uncertainties related to anti-corruption prosecution office and shortage of staff. How would you comment this finding of IMF? The development partners, when they are helping the Republic of Moldova, they oftentimes come with conditionalities. And we, as representatives of the civil society, are asking for conditionalities, because any support should be accompanied by certain reforms. On the basis of this statement, I understand that with respect to strengthening the Anti-Corruption Prosecution Office, Moldova still has some tasks to accomplish. Moldova needs to find a solution how to strengthen this institution, to allow prosecutors investigate impactful cases, and for that certain steps have to be made. I do not see it as a failure, but as a request that will be fulfilled, because we need this institution to be strengthened and able to produce deliverables. So let's see what would be the attitude and the decision of authorities. Because now the governance should finish this initiative once it has started it, whereas having this legal opinion from the Venice Commission, they need to take it into account. I don't know whether you asked me, but I would like to tell you, I would like to share my opinion. To this statement made by IMF. So the IMF reports focus on the Anti-Corruption Prosecution Office after the Minister of Justice made the amendments which expressly delimited the competences between National Anti-Corruption Center and Anti-Corruption Prosecution Office by appointing one institution in charge of investigating high corruption cases. So back then, they recommend to strengthen this institution. We focus on delivering results with regards to examination of corruption cases, whereas rule of law is about the efficiency of the prosecution, how well they investigate, how the cases are sent to courts, how they are examined in courts. And to have efficiency, you need to have the needed tools in place. And the key institution is the Anti-Corruption Prosecution Office, so it's natural for IMF to focus on the need to strengthen the capacity of anti-corruption prosecution office. We have received the opinion of the Venice Commission. We have the commitment as a state to consult all draft laws with the Venice Commission, and we will do our best to make sure that authorities that have these responsibilities and duties to have all of the needed mechanisms and duties to be able to provide track record, because efficiency and sustainability is measured with figures that we will submit annually to the European Commission. We already have a system set up by the European Commission. Since 2024, the Republic of Moldova, together with other candidate countries, is filling in data on the e-platform. A number of cases initiated, number of final solutions. But between initiated and final solution, we submit all of the information about operative measures taken, court sessions, and to be able to fulfill our commitments, we need to have strong institutions, well-paid human resources. And I do not believe that it is a bad thing that they highlight the need to strengthen the capacity or the need to provide additional resources. That's a natural thing. This is the commitment of a country that wants to become an European state. Thank you very much. We have reached the end of this forum, Justice Sector Reform and Fighting Corruption. Of course, the topics that were addressed during these days are still important, are still topical, as you've said yourself. So now what counts is responsibility, honesty, and engagement of each and every stakeholder who can contribute to what we are calling reform that could have an end, though we have mentioned that we can always find something to improve. But the justice sector reform is the Achilles spot, very important for the EU accession goals of the Republic of Moldova. Thank you very much to everyone. Thank you and have a great evening. A question? Do we have time for a question? Okay, please. Good evening. You are the strongest for staying till the end. I am Elena Ghidelica, Deputy President of the Union of Retired People of the Republic of Moldova. I will not use legal terminology because I'm not from this profession, but I will use the terminology as we speak at the grassroots level. 30% of the Moldovan population are retired, and some retired people. So we have representative offices in all districts, in all villages, from north to south, east to west, and we are the poorest or vulnerable group of people. And they say that they do not trust the justice sector. And if they have a problem, they want it to be resolved today and now. And during these 2 days, though I'm not a professional in the judiciary, I don't understand that time is needed to take a decision. And I've seen that each institution presented its strengths, its weaknesses, progresses, achievements, and drawbacks. And when I say that I'm traveling to meet people at the local level, and I hear the complaints of people. So my question is, when I meet them, what should I tell them? So I will tell them the following. Look what is happening in the justice sector. As a conclusion, justice sector is like an iceberg which has started to melt. And when it is melting, no one can see it. But there are movements. So the same is happening here. I've seen that all of the institutions are ready and are prepared to improve the judiciary. Thank you very much. Thank you. And now we're saying goodbye. So all the best to everyone.